Fellow councilors, to my left, Councillor Tara Jacobs. Next to her, Paul DePalo, Terry Kennedy, and Eileen Duff. And to my right, Marilyn Petito Devaney. At this point, I'm going to read a letter dated February 7th, addressed to the Governor's Council. Dear councilors, I'm pleased to nominate Francis Kenneally to the position of Associate Justice of the District Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. Sincerely, Maura Healy. So at this point, I know you have a lot of distinguished people here. You have a pretty amazing witness list, so we'll hear from them first, and I'll go in the order that you gave me, because you got all, this is like an all-star panel. I don't want them to be mad at me. This is your list. First, we'll hear from the Honorable Frank Gaziano. There he is. Good to see you, Judge.
Good to see you, Council. Where should I sit?
You can stand, you can sit, whatever you like.
Got already with the get appointed, you
PTSD. Let me thank the council for the opportunity to speak on behalf of Frank Kenneally. My testimony is based upon over 30 years experience with Frank Kenneally. I met Fran early in the 1990s when I was a new clueless lawyer. The most striking part of those early days is that Fran at that time treated me the exact same way he treats me now as a senior member of the SJC. Every single phone call that I made to Fran about immunity petitions, gatekeeper petitions, full court appeals, and with, how can I help you? Not as hollow platitude. He provided welcome, well thought advice to anyone who called, no matter where you were, position on the court, or your newness as a lawyer. Now, I want to discuss 4 qualities that speak to Fran's qualifications for the district court bench. First is his competence. For many years, I've watched Fran handle a wide variety of complex legal issues, criminal cases, civil cases, judicial discipline. He has provided guidance in these areas to SJC justices and countless members of the bar. The work is not well known to the public, and often we come across tricky legal issues that require further briefing or remand to the trial court. When we discuss our cases amongst judges and we come across one of those issues, we all stop and say, let's ask Fran. We count on his legal advice. One notable example of a case that he worked with me, myself, and Chief Justice Gantz and Special Master Brian O'Connor, navigating complex litigation and reporting requirements over the prison population during the COVID-19 crisis. He has a solid grasp and breadth of a wide variety of areas, criminal and civil. The second is his experience. I believe that his experience in the SJC would be an asset to the district court bench. Most district court judges do not have appellate experience, and Fran will add a valuable dimension to the bench. Issues arise that require Fran's wealth of experience, such as how and when to report a case to the appellate courts, how to properly frame an issue for later appellate scrutiny, what to do when a case is before the single justice, what type of factual findings are required, and what does deference to factual findings mean in a particular context. There's a need for, in that court, to include perspectives from a wide variety of lawyers and clerks. I think Fran will fill a need there. Third is his temperament. Fran has a long and distinguished history of great temperament in dealing with the court staff, lawyers, self-represented litigants, and public. I've known him for over 30 years, and I can state without fear of exaggeration, he is one of the kindest, most sincere individuals I've ever met, period. Lastly is humility. My view on humility has evolved over the years as I hit my 20-year mark on the bench. That was important to start, and now I feel it's indispensable. To me, it means the ability to ignore the fact that everyone stands when you walk into a room and is required under pains of contempt to call you your honor. Humility is recognized in the very human fallibility of others, more importantly, in himself. Seek to improve every day and never forget that he's been entrusted by the governor and yourselves with a tremendous responsibility. Fran will be a fabulous district court judge. I urge you to vote in his favor.
Thank you. Any questions of the councilors? Councillor Tara Jacobs.
Thank you. I really appreciate all that you shared. I wanted to ask, so as a new member, I'm not sure how long you've been at the SJC, and I'm wondering if you knew Brandon his first incarnation with the when he first was at the SJC, or just more recently. Just get a sense of the depth of your experience with him.
Sure. So I've been on the bench for 8 years in the SJC, and before that, I was on the Superior Court for over 10 years. And I knew Fran in both those capacities as he worked for the full court. And then before that, when I was a practicing lawyer, starting in 1989, I met Fran and knew Fran because he was the clerk in the single justice session. And when you're a new lawyer, and you don't know what you're doing, and you try not to get blocked by people like Terry Kennedy, you rely on the clerks to tell you what to do, what to file, and to navigate things. And I would just call blindly the clerk's office because I had to go there for different things. He would answer the phone, how can I help you, and walk you through everything. And it wasn't just me, it was everybody. So that's how I got to know him way back in the 1990s.
I appreciate that added context. Thank you.
Thank you, Councillor Devaney.
How nice to see you. My proudest vote. Not only one, but in the Superior Court, the highest court. And also I want you in the Commission of Social Justice. And for people who don't know, that is a commission where we try to highlight Italian Americans, outstanding Italian Americans, and to fight the discrimination of Italians, the mafia and all of that. And we were just so delighted to have you. And I've watched you through the years, and unbelievable. Every vote that you've taken is with integrity. So having said that, I'd like to know what quality, out of all the qualities you've said about this nominee, what is the most important that he brings to the bench?
Thank you for your kind words. I think the biggest quality I could have in when people appear in front of you, given your lofty position and the amount of authority you have on the bench, it is that quality of empathy and humility, judge people as they come in on their worst day, and to recognize people, frankly, don't deserve a break, but most people do. And I think as I've seen Fran interact with people, self-represented people, people in our court, people in different situations, he has that quality about him to serve the public very well.
Well, I would say that your quality is integrity out of all of them, and to represent this nominee. Thank you.
Thank you.
Thank you very much. I don't have any questions. Good to see you again. You're doing a great job. It's good to see you. Thank you. Next, we'll hear from the Honorable Serge Georges. Good morning.
Good morning, Mr. Chair, and members of the council. Good morning. This is probably one of the more important days of ever having to appear in front of you. I don't think I've had the pleasure of saying anything before Councillor Jacobs or Councillor DePalo, but I'm so honored that the nominee asked me to be here today. Yesterday, before coming here, Justice Gaziano suggested to me that, hey, why don't we meet to make sure that we don't say the same things and that we, and everything that I told him I was going to talk about, he talks about everything. So the pre-meeting accomplished nothing. So a lot of what you're going to hear is going to be just what was just talked about. But this is actually slightly different because all of you have been asked over the years to either write a letter of recommendation or recommend somebody for something. So this is, although I'm sure you have his application and his qualifications speak for themselves, this is slightly different. This is more of something that I'm saying to my friend about what a good man he is and how much he absolutely deserves this. I am incredibly protective of the community courts. The fact that some of you voted for me to be on the SJC, and I know that to a lot of people that is the highest court in this Commonwealth, and therefore this should be the honor of a lifetime. But I will tell you, and I don't mean any disrespect to your vote the last time, but having to preside in the community courts, particularly the court for the neighborhood I grew up in, is without a doubt the highest professional honor that I've ever had. And one of the things that makes me protective about that court is because there are a whole lot of people that come there that are just sinners. They are not criminals. And you need to have people in our community courts that serve on the bench that know the difference between someone who violated a criminal statute and someone who is a criminal. And that is really critical to understand, because most of the people that come through the community courts are not criminals. They suffer from things. They suffer from many of the things that we don't have. And you heard from Justice Gaziano, not to say that he would give everybody a break just because they deserve a break, but more so because he knows the difference between the two, because he suffered through heartache and he suffered through sadness. And he knows that sometimes you just need a little bit of help to get along. And the fact that you're going to have somebody that will hold people accountable, but still give them an opportunity to earn a dismissal or to be better than they were before is exactly who we should have on our bench. And you are never, ever going to come. You will find others that are just as good, but you will never find a better candidate for the community court than you have in Fran Kenneally. He is, without a doubt, one of the best people you'll ever meet. And I can't begin to tell you how he will be one of the best judges that you will ever vote for. I'm happy to take questions, but again, Justice Gaziano stole everything. But Councillor Devaney, I do want to mention that I am an 8th Sicilian. I am on my mother's side, and so to the extent that we're doling out honors to Sicilian justices.
My father was born in Sicily, so.
Well,
I want you to know, I wanted to recuse myself because I did not know that when I voted.
there is a large contingency of Haitian Sicilians roaming the world, and I happen to be one. So with that said, I'm happy to take any questions that you might have, but that's what I got.
First of all, Justice, I want to make a commitment to you. If you and Gaziano ever come again at a hearing, I give you my word, you're going first.
If I may, Mr. Chairman, I just want to say that I've been on here for 14 years. The Dean's been on a lot longer. I've never seen a situation with 2 SJC justices show up to testify for witness, and that's pretty astounding. And
It is
It
astounding.
really says a lot.
Well, Councilor Kennedy, I would finish that thought and tell you that it says more about him than it does us.
I know that. You're right. That's my point. It really does say a lot about him. So I think it means a lot to everybody here. And, you know, it weighs a lot on me because I know you 2 guys can disbar me.
You know, that is within your ability, because it's only for cause that we do that, right? So.
Be in trouble.
At that, Councilor Devaney.
I just want to say this is my lucky day to have 2 judges that I was so proud to vote for, and you have made me proud. And I just want to ask, you've been following him all these years. Tell me, is there one case that stands out that really impressed you?
Not necessarily a case, but a letter. You know, we have, every month, we have these monthly administrative meetings. And coming, you know, I joined the court during the COVID pandemic, so everything that we were doing was on Zoom, and so it was a new world for even the practitioners. And a couple of months or maybe a year or 2 into being on the court, during an administrative meeting that we had, Chief Justice Budd read a letter that was written in to the court, to her, from a practitioner that talked about how much Fran Kenneally made their lives so much better by having meetings ahead of time to go through how the technology worked, what the cues were going to be, all of the things they needed to know. And what it underscored was, it was somebody that it was important of the business of the court to be done, that he would go out of his way to go above and beyond to make sure that the attorneys and the experiences of the people that were coming to the court were as good as it can be if we were in person and live. That is what stands out to me.
If they all would do that, isn't that wonderful?
And imagine having someone in the chaos of a district court session where probation may not be ready, the clerks may not be ready, or the lawyers may not be ready, and all the alchemy that needs to happen in order for a case to be called, to have this guy running the show, game, set, match.
Pandemic, you people.
I can speak for the court and say for our court, it was Frank Kenneally.
Well, your testimony means a lot. Thank you for coming.
Thank you. I look forward to seeing you all again. And thank you, Mr. Chair, and thank you to the council.
To see you again. Thank you. Next, we'll hear from the Honorable Maura Doyle.
Good morning, Mr. Chairman.
Morning.
I have taken the liberty to write my remarks, but I will mention that I was not consulted to sit in with Justice Gaziano or Justice Georges. But now I know why. Anyway, I also wrote my remarks out because I have a lot to say about Frank Kenneally, and I certainly don't want to belabor it here at this meeting. So good morning to all of you. My name is Maura Doyle, and I am honored to appear before you this morning in support of the nomination of Francis B. Kenneally for a seat on the Massachusetts District Court. As I'm sure you know from reviewing Attorney Kenneally's judicial questionnaire, he has been an attorney for 37 years and a member in good standing of the bars of Massachusetts, Maryland, and the District of Columbia. His legal career includes extensive civil and criminal litigation in the state and federal courts, appellate practice on the state and federal level, real estate, residential and commercial practice, probate administration, estate planning, and of course, he appears before you this morning as the clerk of the Supreme Judicial Court for the Commonwealth for the past 10.5 years, where, as you have heard, he has distinguished himself as one of the most responsive, accountable, and professional public servants in the Commonwealth. Although I could speak to you in depth about his collaborative work with 25 Supreme Judicial Court justices and 5 Chief Justices, I prefer to speak to you today about Fran Kenneally, the man, the colleague, and my friend. I have known Fran for more than 43 years. We first met in the fall of 1980 when he came to work as a high school intern for then Representative and later Senator W. Paul White of Dorchester. I was also working part-time for Representative Paul White in the Judiciary Committee on a special joint commission on uniform sentencing and revision of the criminal statutes during my 3rd year at Suffolk Law School. My first impression? Wow. What a conscientious, hardworking young guy who was willing to do anything asked of him and to do it well. It was here at a very young age that I first observed Fran's innate passion to help others, his innate passion for public service. And I still clearly remember attending his graduation from Boston College High School in 1981 and joining his family and friends and State House co-workers to congratulate him and wish him well as he left to attend college at Fairfield University, where, of course, he honed his leadership skills as president of the Student Association. It was obvious to me that Fran was going to excel in whatever profession he chose, as long as it was in furtherance of service to others. And so when Fran decided to become a lawyer, it was no surprise to all of us who truly knew him. But the work of all lawyers is basically to smooth out difficulties for our clients, to relieve their stress, correct mistakes, and in essence, to take up our clients' burdens and help them as they strive for justice. And that's why in 1997, after he finished law school, He finished up with 6 years of practice in Baltimore. I jumped at the opportunity to hire Fran to the position of public service as an assistant clerk in my office. What most people, as well as attorneys, do not realize is that the Supreme Judicial Court is not just an appellate court, but it's also once was a high trial court. It is my side of the court, the county court, the single justice side of the court, that is the vestiges of the SJC's trial court function. It was while working in my office on the single justice side that I witnessed Fran's knowledge of the law, his trial experience, his procedural acumen, his superior writing skills, and most importantly, his passion for public service all converge. But you see, it's the single justice side of the court where busy and often stressed trial lawyers, like Justice Gaziano, for instance, not necessarily accomplished appellate lawyers, these stressed trial lawyers, as well as self-represented litigants, they seek emergency relief. And this is where Fran's inherent qualities of empathy, humility, and patience became readily apparent. I remember one specific instance very early on when a homeless, destitute man came to the clerk's office seeking help. He had been evicted, his belongings were all in storage, and he had no job. Fran sat with him, advised him as to what pleadings he should probably file. But then after learning that the man had been a painter, Fran gave him the phone number of a painting company in Dorchester where he might get work, get back on his feet, and hopefully be able to find and pay for housing. This is the man who's before you today. A man who is not only skilled in the law, but committed to helping those in society that others just don't see. On another occasion, a young lawyer, a new lawyer, came to my office seeking information and guidance. And a few days after Assistant Clerk Kenneally met with him, he received the following note. Dear Mr. Kenneally, I came into your office last week looking for information on limited assistance representation. And rather than sending me to another office or simply giving me a number to call, you took the time out of your busy schedule to look up the rule, make the necessary calls, and even walked me to where I needed to be. I truly appreciate all that you did to help me and the advice you gave me. Your kindness was refreshing. As a new attorney who is just beginning my career, I have not encountered many people who are ready to go out of their way to help as you did. It is through people like you that the integrity of our profession remains. I've also been of the mindset that whenever a person is being considered for the bench, it is the people who work for the nominee who should be consulted. This is how one, as you have done many times, I'm sure, learns the true demeanor of a judicial candidate. In anticipation of my remarks today, I asked several of my current long-term staff what it was like to work under Fran. And although they all mutually agreed that working with Fran on a day-to-day basis was a pleasure, I'd like to share with you one particular observation. Working for Fran Kenneally has been nothing short of exceptional. He never let any good deed or any job well done go unnoticed. He was always complimentary of hard work and made it a point to recognize it and celebrate it. He could handle any person from the most professional people who came to the counter to someone who was about to become homeless, and I got to witness his compassion for people as he offered guidance and assistance. He never treated anyone differently, from attorneys to a struggling man coming in with his children about to lose their home. He was always a courteous gentleman, and this is a quality of his I have always admired. It made me very proud to work for him and I am a better person for knowing him. End quote. So in closing, friends, in my personal and professional journey, I can't believe I'm.
You're making me cry.
Oh, why I cried? Thanks. Know me too well. I thought it was just because I'm getting old and my right eye waters. Friends in my personal and professional journey together, from his high school days to working shoulder to shoulder as clerks of the highest court of the Commonwealth, has been a privilege and a blessing. In my 43 years at the bar, I have never worked for any lawyer or worked with any lawyer quite like Fran. A man who possesses all the intangible qualities of intellect, compassion, patience, and humility. If appointed, I assure you that he will serve on the bench with honor, fair-mindedness, and authority without arrogance. Thank you.
Thank you. Any questions? Councillor Devaney.
Sorry, I don't.
No, your testimony means so much and your presence here too. Thank you. And you, out of all of the attributes that we could say, I think compassion, and I've said it many times, I won't vote for anyone if they don't have compassion. And he has it stamped in his forehead. So, and you brought it up, but you were his boss.
I was.
So you saw this. So, he was always there reaching out to people. Is there any incident that you can tell us about? That was one that we heard about, but, tell people, you know, to tell people what to expect, I think that's, you know, and you're afraid you don't know what's going to happen, and that's a big thing, yeah. So what would you say?
Other instances of compassion? I think at the death of Justice Gantz, who both Fran and I were very close to and enjoyed working with. They're cut from the same cloth, and the compassion that he showed Justice Gantz's family on that loss, the compassion that he has shown other people in our offices who have lost family members, you know, is outside the practice of law. He takes himself everywhere he goes, Councillor. And as I think one of my staff mentioned, it doesn't really matter whether you're a justice of the Supreme Judicial Court, whether you're the clerk of the court and he's an assistant clerk, whether you are a homeless person, whether you are a co-worker. He does not discriminate. He just kills everyone with kindness. And but he's not a pushover. He's very deliberative. He's very thoughtful in his dealings. But I could think of probably a lot more instances.
No, that means a lot, and I don't separate the personal from the public. That's the way he treats people from her in his personal life. And as far as Justice Gantz, I personally had a wonderful relationship with him, and what a loss. And he would take as much time with me, who am I? But he would take time, and I could maybe be a half hour with him, and someone would say, you have to come out, Judge, and wait a minute. But that's what I found, and that's what you see.
They are exactly alike in that regard.
That's wonderful. Your testimony means a lot. Thank you so much.
Thank you very much. Good to see you again.
Thank you very much, Council.
We have one more witness, and that will exhaust the list. Former sheriff, former Superior Court judge, my good friend, Bob Rufo.
Thank you very much, Councillor Iannella and members of the council. I wanted to just very briefly thank this body for giving me the opportunity twice to serve the Commonwealth as a justice of the trial court for 24 years. My brain fried a few years ago when I turned 70, but I still have a little fight left in me. At the first instance that Fran mentioned to me, which was about 2 years ago, and I met him probably back around 2010-ish, so I didn't know him as long as Mara did. Ralph Gantz got me involved in too many committees on the SJC while I was trying to be a judge. It was attorney conducted here at the Jury Management Advisory Committee, the list goes on. But I had a chance to work with him in my capacity as a judge to get information and to work on these committees, which really impressed me, as all of us have already said, with his passion and his diligence and his temperament. Now, I mentioned the word temperament because as a new judge, he has to go to new judge school. We all had to do that. And there's a course in new judge school, and I mentioned this to Fran the other day. It's called Judicial Equanimity, because we wanted to make it sound good. But equanimity really is about temperament. And I know right now, I can say this with confidence, that Fran will get an A in that course because he already has the temperament and the ability to act responsibly under stressful circumstances, which oftentimes a judge, he or she, finds himself to be in. So that's all I wanted to offer to you, Councillor Iannella, and members of the council, that he has the ability at this moment to maintain that judicial temperament that people need when they enter the bench and take on the responsibilities as a judge of the trial court. So thank you for giving me the opportunity to speak.
Thank you very much. Councillor Devaney.
Change, you look great.
I'm old.
I grabbed 2 votes that I had for you, and I want to thank you for your service. And
1996 and 2004, and Councillor Iannella was here for both of those. I'm not going to tell you how old he is.
Wow.
thank you. Your testimony.
Thanks.
Hold on. Councillor Ferriera has a question.
I just want to thank you for your service and from, I took the ride from Falmouth to here just now. So I appreciate your ride from Cape Cod.
Ferriera's my counselor.
Now, your phone call the other day was very good. It was your input. Thank you, sir.
He's a great man.
Thank you. That will exhaust the folks in support. Is there anyone in opposition to the appointment of Fran Kenneally? There being no one in opposition, I'll close that portion of the hearing. And at this point, we'll give you the floor, and you can tell us why you think you should be a judge of the district court.
Thank you, Councillor Iannella. I'd like to introduce.
Also, excuse me, you can also introduce your friends and family who have not already.
Thank you very much. With me are my daughter Emily and my daughter Caroline and my brother Paul Kenneally. I also want to say that both my wife Kathy and my daughter Kate are sick and couldn't be here today, and I'm very sorry for that. For them, it's a bitter disappointment because for the last month or so, I've spoken of all of you so much. She thinks you're family. So, and that's, but she's watching. They're both watching. My son John lives and works in New York City, and he could not be here. I also want to recognize, of course, all my friends from the Supreme Judicial Court who are here. I'm very grateful for their support today. I won't name all of you, but I thank you for being here. Thank you. My heartfelt thanks go out to Justice Frank Gaziano, Justice Serge Georges, Clerk Doyle, and Judge Rufo. Thank you very much for being here. The best years of my professional life have been spent at the Supreme Judicial Court, working with the most dedicated people I know. Chief Justices, Associate Justices, and the extraordinary staff. I extend my sincere thanks to Councillor Iannella for hosting me, and to you, the members of the Governor's Council, for your kindness and courtesy during this process. I appreciate the hard work of the Council's Administrative Office, Valerie McCarthy, Sonia Altamirano, and Aaron Thomas. I'm grateful to Governor Maura Healey for my nomination. I'm also grateful to Lieutenant Governor Kim Driscoll. Throughout this process, I have been so fortunate to receive expert guidance and support from the Governor's Legal Counsel, Paige Scott Reed, and Deputy Legal Counsel, Dara Kesselheim. I'd like to recognize the extraordinary efforts of Chair Abine Thomas and the members of the Judicial Nominating Commission. I'm also grateful to Marty Healy and the members of the Joint Bar Committee for their support. I humbly recognize that no one gets here on their own. I've been carried here on the shoulders of so many people. I have confessed to some of them and also to some of you that I approach this moment with some apprehension because I've never had a public job interview, especially one that is streamed live. The advice I have received has been consistent, clear, and very helpful. Be yourself, talk about your background and experience, and why you think your background and experience will make you a good judge in the district court. So in my brief remarks this morning, I would like to share how my upbringing has helped shape my values and how that informs how I treat people today. My growing up in a tinderbox row home in Dorchester was not always easy, especially for my parents. With 6 kids, their love and support shielded us from the harsh realities of life that can often disrupt childhood and adolescence. My mother, Claire, now 90 years young, is the strongest person I've ever met. Her grace in the face of tragedy, especially with the sudden loss of my brother Steve in 2004, and managing an often chaotic home, taught me the values of perseverance and patience. My father, Jerry, was the most caring person I ever met. What we lacked in resources, he compensated for with hugs. The difference in his adolescence and mine could not be more stark. When I was 16, I spent many carefree nights hanging at the Garvey Park in Dorchester with my friends from the Garvey Athletic Club. When my father was 16 and already orphaned, he spent many restless days at the Roberts Field in Dorchester trying to find a way to sneak into the Navy to join his brothers Joe and Fran. At 17, I was still hanging at the Garvey Park. When my father was 17, he was on a ship fighting in the South Pacific. I graduated high school and went away to college. My father never graduated high school, and after the war, went to work as a welder at the Four Rivers Shipyard in Quincy. From him, I learned the values of hard work, tolerance, and respect for all people. Particularly formative for me growing up was closely observing my parents in the early 70s during the busing crisis in Boston, a period of racial division, tumult, and violence. Despite these deep divisions, my parents made it very clear by their words and deeds that hate had no place in our house. Their influence and example inspired me in high school to join the Covenant for Justice and Equity movement in 1979 to help mend racial divisions in Boston. That influence guided me toward law and continues to motivate me today. When I look back at my legal career, it's not the steady stream of trials, depositions, and motions that motivated me. It's those times when I felt that I truly helped people, whether it was dispensing legal advice to unhoused persons with mental health and substance use problems on the streets of Baltimore, or representing people facing criminal charges as a bar advocate through Suffolk Lawyers for Justice. I have worked for a civil litigation firm with a national practice, and as a solo practitioner with a local practice. It is my work as a solo practitioner that has best shaped how I help people in my current role and how I would help people in the future. I know what it is like to have to be in 3 places at the same time, to make payroll, and to be on the first name basis with everyone who works at Staples. These experiences have been critical to my work in the public sector, especially during my time as clerk of the SJC for the Commonwealth. Throughout this process, I have understandably been asked, why would you ever leave the rarefied air of the SJC to serve in the district court? Much of my work at the court is spent triaging, putting out fires and putting off for a short time the less urgent matters. In many of the motions that I decide and the disputes that I help resolve, it usually comes down to the parties seeking simple or complex procedural guidance, or lawyers and self-represented litigants in need of breathing room due to professional pressures, personal crises, or even the need to take a week off without having to worry about their cases. I am guided by simple unwritten rules. Don't elevate form over substance. If you help someone, never give the impression that you've done them a favor just for doing your job. Don't weaponize court rules and procedures to embarrass someone or deny them access to justice. Help everyone who needs it, whether they have a case with us or not. These simple rules would guide my service as a judge, and I will always have a deep and enduring appreciation for the indispensable role of clerks. In the district court, I know that I will have an infinite number of opportunities to help people who have trauma, mental health problems, and substance use disorders, and for selfish reasons. My deepest motivation stems from the loss of my brother Steve due to his mental health challenges and his son Connor, who we lost in 2015 during the opioid crisis on Cape Cod. I firmly believe, if asked, the intervention of a district court judge could have saved them. I would be honored to bring my passion for helping others and my compassion for those seeking justice to the district court. Thank you again for your time, and I welcome your questions.
Thank you. Councillor Duff.
Thank you, Mr. Chairman. It's really a pleasure to see you, besides all the wonderful emails you sent us. But you have such a stellar reputation, and I've heard from people that literally I never hear from, singing your praises. So I don't have a lot of questions because frankly, pretty much everything I need to know about you, demeanor being one of them, no. But I'd like you to share with us a little bit about the initiatives, the number of initiatives, the initiatives during COVID that you had to deal with, and how the use of technology in implementing that at the time, because I think our courts, and I know you were somewhat involved in it, but you know, we were in not just a local emergency, we were in a global pandemic. And I think people forget that. You know, and yeah, there were blips and things probably in some of the courts. I mean, we had a housing judge who actually kept the whole housing court open, but we had people criticizing because they didn't like how some of the stuff worked. The fact that it worked at all, the fact that you guys were able to implement it, to me is really heroic. And I mean that in, you know, I have a classic education like you do, you know, I mean heroic. I mean in that sense of what that word really is. So if you could share that with us, that's the one thing I'd like you to expound on.
Thank you for asking that question, because what it helps me do is shine a spotlight on the unsung heroes during the pandemic. And that's JISD, the Judicial Information Services Department, the people that equip us with the technology to do our jobs. We didn't miss a beat. And so they're the ones who equipped us with our Zoom licenses and our all of our technologies. So I'll be eternally grateful for them to allowing us to continue operations. I think there were many, many initiatives during the pandemic, and I was unaware of the letter that Justice George has read or talked about. But part of my goal in my job has always been, how can I diminish apprehension in anyone? So when the SJC wanted to be back in the building as early as possible, I think to send a message that we're back in business, I did hold about 70 meetings by Zoom with attorneys. And I even videotaped this amateur video to show them what it would be like walking into the new world after being away for over a year and a half.
Yeah.
So those sessions were extremely rewarding for me, because it was an opportunity to diminish apprehension. There were people who did not want to come back, were afraid to come back. It was just before the vaccines were as effective and pervasive. And so there was a lot of fear still. So to be able to use those as a vehicle to diminish fear among people was very, very rewarding. And what was best about it is we didn't force anyone to do anything. This hybrid model we came up with, if you were at home and you wanted to argue from there because you felt safer, we accommodated that in the same case. If you wanted to come in, we had protocols set up to make you feel safe. So those sessions were very helpful in explaining to the parties coming in what we had done and how we were going to protect them if they chose to come in to see us.
Thank you so much, because it really goes down to the basic, and I know Justice George and I have talked a lot about this, access to justice. I know he chairs committees on that. But, you know, we throw phrases around a lot, but justice delayed is justice denied, right? And the fact that you were able to be part of that team and lead that team, and thank you for acknowledging all those workers, because to me, honestly, it's something that people forget about. You know, we're past COVID now. The vaccines are pretty darn good if people get them. But it was really we'd never seen anything like it. And so thank you for sharing that, because it really, to me, was just a tremendous team effort at the very highest level of our court system to make this work. So thank you. I have no other questions.
Thank you very much. Councillor Terrence Kennedy.
Good morning again. I told you outside, I received countless letters. Judge Rufo had called me, Paul Dolly, Justice Paul Dolly called me yesterday. Sharon Casey, the clerk in Cambridge, former executive director of the JNC, texted me this morning. And everybody said the same thing. Is Kenneally going to be okay? And my answer was yes, he's going to be okay. Don't worry about it. And I'm not going to list them all. There were tons and tons of calls. I'm going to ask you a couple of practical questions that about the district court and Spirit, but you're going to district court. That I'm seeing that I don't particularly like going on right now. And the one thing that, we got out of the pandemic, the one good thing in terms of the court system was how fast they ramped up in terms of the technology, in order to keep up with things. When the pandemic hit, if somebody had told me that I would be doing cases on Zoom, I would have said, "What's Zoom?" I had no idea what it was. And I would sit there and even after we were back to work a little bit, and I'd be able to do a pretrial in Plymouth in district court. I'd be able to do one in Newburyport. I'd be able to do one in Lowell, sitting at my desk. And I was doing work at my desk, all done with that at 10 o'clock, as opposed to driving around like a maniac and having judges mad at me because I'm 2 hours late. A lot of courts are doing away with that. I guess the rule basically leaves it up to the presiding judge in terms of lawyers being able to Zoom in. I know in Lowell, they don't do Zoom anymore. I know in the BMC, they don't do Zoom anymore. Isn't that going backwards? I mean, it seems like that was a really great advance in terms of efficiency.
I think it should be a sustained technology. It's the reason why I'm advocating for it to continue at the Supreme Judicial Court with our oral arguments. So there are some proceedings that absolutely make sense for Zoom and others that do not. I would draw the line at evidentiary hearings. But when it comes to a 5-minute pretrial hearing or talk about discovery compliance election, I think it's perfect for a Zoom hearing. And so I think more uniformity across the system would be.
Well, that was my next question, is the lack of uniformity, because one court has this rule, one court has that rule, one court has another rule, because they basically left it up to whoever the presiding is in the district court. And when you're moving around, and they already have your seat wound up in Region 3 for you, the judge has already told me that they're very bad. It's you know, the inconsistency makes it difficult for lawyers to figure out what they're supposed to do in a particular court, especially if it's a court they don't usually go to.
I can tell you what I would do as clerk of the SJC, and I do it now for those types of, we just had a battery of conferences by Zoom just last Friday in our murder cases. So it should be a tool that's continued to be used with uniformity. And I don't know what the answer is, but I do know.
How do we fix it? Do we talk to these guys?
Well, yeah, they might. I do think it's something that should be more uniformly.
Yeah, I think so. The other part of that equation is the defendant's present during court. Some courts are saying it's still okay if they're not there at a pretrial or a compliance and election date, basically an event where they're not really participating, let's say. It's not like a trial or a motion. I agree they have to be there. But, you know, most of these people, you know, if they have jobs and they start missing work because they go to court a lot, they're going to lose their jobs. And I think the one thing we want everybody doing is working, because that's one of the things that's going to keep them from coming back to court in a different case. How do you feel about the defendant being present on every single event? Because that's happening in some courts again now too.
Sorry to hear that. When I was a bar advocate, I routinely asked for my client's appearance to be waived at the next hearing, Your Honor, and it was routinely allowed in the BMC. So I'm sorry to hear that.
I mean, I go into some courts, my client's not there. The judge looks at me and says, "Have you been in touch with them?" Yes. Yeah. Okay, that's fine. And we move on, we do what we have to do. Other courts, where's your client? And once again, we have the issue with the inconsistencies there. I personally, unless there's something special going on with a particular case where probation wants to see him, he's on a GPS, he's doing drug tests and whatever, unless there's something specific going on, that there's no need for them to be there on a non-evidentiary date.
I shared with you my first unwritten rule, which is don't elevate form over substance. And to me, you're striking at form over substance here. It's something as someone that had to hustle as a solo, I get, I understand.
The other thing that you're going to be facing in post-pandemic, there was obviously a huge backlog in the district courts. I had a backlog myself of cases to catch up on. I'm just catching up now. I expect I'll be probably caught up by the end of the summer. I'm in court every day. I try cases all the time in the district courts. sometimes in the Superior Court, but I'm trying to get away from that. I don't want to work that hard anymore. But there's a big push on to move cases, time standards, time standards, time standards. I'm hearing it over and over and over and over and over. And a couple of things happen when you push time standards. One is it basically puts all the pressure on the lawyer who's trying to make a living and trying to juggle cases. You know, I tried a case in Plymouth 2 days ago, and I tried one yesterday in Haverhill. I'm all over the place. You know what I mean? And a lot of lawyers are. And it's difficult to just keep going from one to the other because judges want to move cases for the sake of moving cases. The other way they move them is they end up dismissing a lot of cases that maybe shouldn't be dismissed. I'll take it, you know, it's good for my client, but it's not necessarily the right way to run a criminal justice system, right? What's your view? What are you going to do when Chief Justice Forts calls you up and said, Judge Kenneally, you've continued these 5 cases that are outside the time standards. What are you doing that for? You're not supposed to do that. How are you going to respond to that?
I'm going to ask her for the list of exceptions to those types of situations, because I certainly hope there are a list of exceptions. When
I don't think there's a list per se, but
what the exceptions are to that, to those time standards, because there should always be exceptions to time standards.
how about this one? How about I'm busy? How about I have a very busy practice and I just can't get them done within that time frame? Like, not just me, but the lawyer.
I deal with it all the time. As a rationale for creating, as I say, breathing room in my remarks.
The reason that I'm gonna vote for you has nothing to do with this great resume you have, or the great witnesses that you had here today, or all the nice things I heard about you on the phone. The reason I'm gonna vote to you is you were incredibly nice to my daughter.
Oh,
Thank you.
Thank you, Councillor DePalo.
Thank you, Councillor. Good morning. I enjoyed our conversation very much, and it affirmed, among other things, what I had already heard around your temperament. And I feel very good about your judicial temperament and our conversations around pro se litigants and even some of the anecdotes that were shared this morning. Along the lines of what Councillor Kennedy was just asking you about, in terms of the time and the pressure to move in district court, the anecdote we heard this morning about the gentleman who was destitute and you helped him pursue work opportunities, etc. As a district court judge, what do you feel the reality of the situation will be for you to be able to make those fine-tuned, tailored considerations amidst the pressure of the court, the workload?
to be honest with you, I think what's going to be difficult for me is to take the exact same approach that I use today when it comes to those situations. And there's a natural barrier in our clerks' offices. And the first thing I do when someone comes in for help is I remove the barrier. I come around and we sit down and have a conversation. There's dignity, there's respect in that moment. And I listen carefully. I can't replicate that in district court. And I don't know how I could possibly replicate that. But the spirit of it is there. I will find a way. The how I don't quite know right now. And I do know that there is pressure to move things along. I think you just have to find a way to move cases, but also not sacrifice fairness and not sacrifice someone's impression of their case before this judge in this court in this moment.
I want to ask you about your views on discretion, because I liked your answer on your application. And you asked rhetorically, to what end? To what end are we exercising our discretion? And you wrote that sentencing should be reflective and not reflexive. Could you expound on what you mean by that?
Sure. I don't do anything in my current job reflexively. I look at every motion, every case as a different case and a different set of facts, a different situation. So the same would go for sentencing. Take time to reflect, take time to look at the complete record, take time to listen, take time to receive letters from educators and employers, listen to counsel carefully. And always ask, to what end? What are the goals here? What are we trying to achieve for this person? For example, with someone with a job with a Section 35 in the balance, a commitment, who also has a charge pending, put that person away, thereby jeopardizing the job and exacerbating the substance use problem, rather than maybe putting on conditions of release that address the problem on an outpatient basis, those types of situations.
I'm glad you brought that up because I was going to ask you about tailoring conditions of release around particular individuals, and we had talked about that. Another thing I want to ask you about your response and discretion, that one of your goals would be to become expert in all statutes and SJC decisions regarding expungement and sealing. Could you explain why that's important to you?
Yeah, it's an area that's complex, and we have experts in the room who have written about it. And it's an area that I would really like to become expert in, because I think that a person through that statute can get a new lease on life, whether it's housing, whether it's employment. And I really, in addition to diversion and those other remedies, I see that as a key. As long as it complies with the statute and the decisional law of the SJC, as a key to giving people a new lease in many ways. So I'd like to explore it very, very, very carefully.
Well, I appreciate your perspective on every issue we talked about. We had touched on a couple other things as well. I love talking asbestos with someone who's dabbled in that practice area. Yeah. We touched on the legacy of the Gantt study, the Harvard study on racial disparities in sentencing. Yeah, as I said, I very much enjoyed our conversation. Your reputation preceded you, your home counselor was on the phone right away, and my phone's been blowing up quite a bit regarding governor's council work lately, but calls about you were part of it, and were the more pleasant calls I was receiving, so it's great. So I have no further questions. I think you're going to be an outstanding.
Thank you.
I look forward to seeing
Sure. Mr. Chairman, can I make one more comment?
Real quick.
Yeah. Two things. One is, as I was sitting here, I got a text from Judge Farrell telling me I better be nice to you. But I too got a call from your counselor as well as soon as you were nominated. And he's been extremely supportive, and he had already twisted my arm before I walked in the door. So
Thank you, Councillor Tara Jacobs.
Good morning. It's still morning. So it's good to see you. I will lead off by just echoing the support of your counselor and how much that means to all of us. We had a really great conversation. I really appreciated you coming out, sitting down with me, and we talked about so many things. And I already, we had met already in your role at the SJC, and I do receive your emails with the updates on the docket and the schedule. And so I already felt like, to some degree I knew you, but really that conversation, I got to know you in such a deep and personal way, and it was really meaningful.
Thank you.
For me, and really, I walked away feeling kind of echoing what was already been said in this room today. But in terms of your demeanor, who you are, background you bring, some of what really stuck with me was your persistence and the way in which you kind of just marched out into the world to kind of carve your path. Is so inspiring. It's rare to see someone who really has just grabbed life and literally knocked on doors to find opportunities. And I think it says a lot about who you are and how you live life. And clearly the relationships with the witnesses we've had today and the letters, emails, phone calls, been receiving, the relationships that you've established are just filled with the same tone and language about who you are, which just speaks to you're just consistently this person who I'll even refer to a call I had with Judge Ireland, who sang your praises at length, but echoed a lot of what your witnesses shared today in terms of you being such a thoughtful and smart and compassionate person. He talked about how regardless, every walk of life, the people you encounter, you show up in the same respectful and just compassionate way. And he alluded to something we talked about at length, which is the focus you brought to ensuring you had a diverse staff and the steps you took. So I want to actually give you an opportunity to talk about that, if you don't mind, and share what he's referring to, what we discussed, but also, so share that, but if you could also then, how that might reflect in how, as a district court judge, that perspective, that focus might reflect back into how you conduct yourself as a judge.
Thank you. That's a great question. Thank you for asking that. I firmly believe that with respect to my office, I don't have a large staff, but in the hiring decisions that I've had to make over the last few years, that has been a chief goal of mine. And we serve a diverse population of people that come into the clerk's office. And frankly, it's as simple as having them come in and feel more comfortable at seeing that there are people who look like them that work in the clerk's office, and that we all don't look alike and we all don't think alike. And it's a better office for it. It's a better office for it. So in terms of a district court, being a district court judge, certainly I would continue to be driven by those types of passions. And I would also hope, though, that the way I'm able to approach people that work with me at the court and people that come into the court can somehow be conveyed from the distance and height of a bench. And that's one of the things that I think I'll have to struggle with at first, but I think I'll find my way.
So that you almost created the perfect segue for my, it's almost like we scripted this and we did not. But I wanted to ask you to reflect on what you think, both from the standpoint of the strengths that you'll bring from the experiences you've had, but the challenges you anticipate facing entering into this role as a district court judge.
Sure. I think the challenges are going to be more for me tied to the volume of work. I'm not afraid of work. I work a lot of weekends at the court, but I think the volume of cases, as Councillor Kennedy talks about time standards and moving cases along, I think that's going to be something I'm going to have to adjust to and figure out how to manage. So I think that would be the first challenge I'm going to face, I believe, as a judge, and try to do that without sacrificing fairness, without letting it feel, leaving the bench and making people feel as if they weren't heard. That to me would be very unfortunate. I think regardless of the outcome of a case, as long as people feel like they were heard and that there was empathy and a connection made, I think that's essential.
I agree, it fully is. I think that has everything to do with how someone feels about the outcome, good or bad, whether one in their way or not, if they feel seen and heard, respected by the court. I think it's foundationally just so important. So I appreciate you saying that. You know, I could ask you all kinds of things, but I really just, I walked away feeling so good about you as a person, your qualifications, and so I'll leave it there. I don't feel the need to ask you further, but just I hope it's been a good experience going through this process, and
Thank you.
it's great to see you too.
We'll continue the conversations by the time if you want.
Thank you, Councillor Ferriera.
Thank you, Mr. Chairman. Thank you. Nice talking to you over the past couple of weeks. I've always enjoyed getting your newsletters on Sundays, your work Sundays, telling us what the SJC is doing. Your reputation's phenomenal. It's kind of weird to get calls, which I get a lot of calls too. People going, is he going to be okay? What do you mean he's going to be okay? It's like I've passed judgment on over 250 judges, and this is one of the best resumes I've ever seen. I think you should have applied for the SJC as well. Maybe it's not too late. Maybe next time. I got calls, from your host counselor here, Judge Rufo, Marty Healy from Mass Bar. Sharon Shelfer Casey reached out to me this morning. Kevin O'Leary, I got tons of calls. Everyone says great things. But your resume is incredible, because it's not very often we get somebody who puts down 45% of your work was civil, 45% of your work was criminal, and you've done every kind of case I can imagine, and 10% of it was probate court as well. You're going to make a stellar judge. Incredible. And just one thing, you know, sometimes like, I don't know if you noticed, but sometimes Councilor Kennedy uses this as a sounding board for bigger things. One thing I want to ask you about, so I got a date in Brockton the other day, trial, and they said 11 o'clock, which I thought was great. So that you don't have to worry about parking, everyone gets here at 9 o'clock. Do you see that as something that should be rolled out? Do you have any thoughts on that? Different times, a rolling schedule?
I've done it at the court on a very micro level though. But one thing we did during the pandemic, and we continued after the pandemic, is to give attorneys staggered times to come to court. And what we try to be thoughtful about is if an attorney is coming from Western Mass, they go on at 11 or 11:30. If someone's local, they may be the 9 o'clock call. Somebody works at the Attorney General's office, for example. But I'm a firm believer in it. I've used it and it works really well. Yes.
I'm a big fan, and everything that Councilor Kennedy talked about as well, not having a defendant in every pretrial, I think it all makes sense. So, congratulations in advance. I think you're gonna do pretty well in this room, and I think you're gonna be a great judge. Apply.
Thank you, Council.
Think about the SJC next time.
Thank you, Councilor. Councilor Devaney.
Thank you for all the time you afforded me. I really appreciate it. It was a pleasure meeting you.
Pleasure.
At the diner. Tell me, what's your most rewarding case looking into there? And I love you even civil and criminal. That's really important to me.
I mean, the most rewarding case, I think, at least within recent memory, is the case that Justice Gaziano alluded to earlier. It was called the Committee for Public Counsel Services and the Mass Association of Criminal Defense Lawyers versus the Chief Justice of the Trial Court, SJC 12926. And this is a case that was, we issued our first COVID order on March 13, 2020. And within 10 days, that case was fully briefed and argued before the full court in a 4.5-hour oral argument, which was the first time it's ever happened in the court's history. And what was important about the case is that at the time we were sitting on a powder keg because we had pretrial detainees and people in the DOC and people that work in those facilities who were vulnerable to COVID. And so this was an extraordinary effort, not only the justices, but the parties and the master to try to get our arms around that potential powder keg. And when it was argued on March 30, 2020, the court issued its opinion. Justice Gaziano was the author 4 days later, maybe even 3 days later, which decided the rights of pretrial detainees and also those under the supervision of the Department of Corrections. And what was remarkable about it was the court appointed a special master, Brian O'Connor. Brian O'Connor, who along with other attorneys in his office, Josh Levy and Rob Roberts, compiled data from the sheriffs about what was going on in their facilities, all in an effort to keep people safe and protect them from disease and sickness and death. And the attorneys with the special master O'Connor from Ropes and Gray easily spent thousands of hours at no cost to the Commonwealth for this effort. And they would send me their weekly reports, I think, for the next year and a half, every week. And they would come in at 9 o'clock, 10 o'clock, midnight, 1 in the morning, and I would get them out to the world when I got them. So to me, that's the case that stands out the most because it called on the best of everybody in the system. And that's what happened.
Well, I was amazed at how many rape cases you had. Could you tell us about that pedophile priest?
Which case is that? I'm sorry.
That was, do you remember it?
No, that might be Council.
Okay, wait a minute. That was, I'm sorry. That was, I'm sorry. You had, yeah, the one you followed up and talked about it. Yeah.
The one we just talked about, and there were a few others they don't come to mind right away, but we covered a lot of ground.
Right, right. Well, you know, the thing is that that I saw in you that you educated people so that they would come in, because people are afraid when they come into a court, they don't know what to expect, and you did some being there.
Yes.
So, what do you feel, I mean, is there anything that you feel that you have to learn now to take this new step as a judge?
In all humility, I have a lot to learn. I think my learning curve is going to be an interesting one. I think in areas such as sentencing, it's an area that I really need to learn more about, and just the mechanics of certain things. But I'll spend the time necessary to do it.
No, I've got a lot of calls too, and Judge Mader and Judge Holgian said wonderful things about you. Everyone says the same thing about you. You're humble, you're unassuming, and you really go that extra mile to help people. So, when you have applied before,
Yes.
and tell me about that. How did that go?
It was a wonderful process. I applied a couple of years ago. And I think I got pretty far in the process, but I think at the end of the day, the numbers just weren't there, but I was treated extremely well by everyone in the process, and
So often everyone thinks they got it and they don't.
Well, you remind me of something Chief Justice Ireland said to me one time, many years ago, because he would push me from time to time to do this. And he would say to me, don't be afraid of no. Don't be afraid of no. Keep going if it doesn't work out the first time.
Oh, I'm glad you did.
Thank you.
Because unfortunately, in that administration, so many good people didn't get appointed. And the sad thing is when they don't, because I know I talk with these lawyers in my district, and they see who got appointed, and it isn't someone really qualified, that they won't apply again. So I want to just say that. Thank you. I wouldn't have had you come into the court system, and the people that support you, I have known decades, and so do you think there should be any changes in the court that you're going to? Does it need some changes?
I think there's a bit of a crisis I'm learning about, in that the pandemic caused a real hit to the number of clinicians and doctors available for Chapter 123, Section 12, 15B, and 35 hearings. And they've dropped precipitously. And so judges I really feel bad for a lot of district court judges who are there at 3:30, 4 o'clock, need a bed. They need someone to do an evaluation, and they can't find someone to do it. And so it's a real crisis right now. And the system has to find a way to get people back. But I think that a lot of clinicians found it much easier, and doctors, to conduct business by Zoom. And they can do just as well with that as their vehicle for making a living.
I'm concerned about that we don't have places for people who are drug addicted, and they're not criminals. I mean, these people are just, I've had two of my friends that lost sons to drugs, and I don't know why, how they got involved, but they're good people. So how can we help these people if we don't have places to send them?
It's a crisis because oftentimes I've talked to district court judges who are really frustrated about the lack of a bed, and they just try to patch together as best they can and triage and maybe find an outpatient place, or even a family member that can keep them safe.
Well, I'll tell you, going to the drug graduations, what a wonderful program that is.
Yeah.
And to see these people, all ages, that have gone through the program and now they're clean. I sit in the back and tears come to my eyes. It's really an amazing program. So if we could have more of those,
I think the expansion of the specialized courts, the drug courts, would be a big help.
Yes, I've gone to the drug courts. I think it's important.
I saw their effectiveness when I was a bar advocate in South Boston. Have sessions,
You think
drug court.
there's racial discrimination in the courts?
Well, that's a great question. I could talk for hours about this issue.
You know what, with times, they're gonna time me. So the thing is that I go out to the prisons and I've met with these inmates and they're petitioning for commutations. And my one problem is, a lot of them don't have advocates, so how many more there that are wrongly sentenced? And that's the thing. The other thing is, on the parole board, I don't think anyone's looking, we need to increase it. We only have 7, 9. Because, these people, I mean, are going from North Conway to Yarmouth, and it's impossible to do the job. And they have to have hearings, and they have to have timely, to have decisions, to have timely decisions. And so we're not having life hearings that we should, or commutation, or pardon hearings, because they're stressed out so much. So I'm hoping, I'm pushing for legislation that they will add to the parole board. It's so needed. So I don't know if you're involved in any of that.
I'm not in that effort.
But it's a whole lot of things. But, you know, the drug addiction is something that we haven't won that war, that's for sure.
I give a lot of credit to the district court, chief justices, Justice Force, Justice Dolly, for expanding those, and I think we could do more work along those lines.
Well, I really don't have any other questions. I'm the last one, so the questions have been asked, but I am, I couldn't be happier that you applied, and this is a new administration, and I'm so happy that we're getting people who are qualified, who are experienced. They're not, it's not a political person jumping the line. I've seen it, and it's so nice to have you, and thank you again for applying. And I know you're going to, you know, make us proud, and I wish you all good luck.
Thank you. Thank you so much.
Thank you very much, Councillor. Good morning. I don't have any questions. We had a lengthy conversation. You know, clearly from the people who spoke on your behalf, and some really impressive people, the calls that I got. You're a real decent guy. Your job at the SJC was about helping people. And I heard that today. You clearly have the compassion, the judicial temperament, your demeanor. I think you're going to be a great addition to the court system. And next week or the week after, whenever your name comes before the council, I'd be more than happy to support you.
Thank you, Council.
Thank you. That will conclude the hearing today. Thank you.
Yeah,
Jacket.
Hey, gang's all here, right? Okay.
Yeah, right.
To go ahead and call our council assembly to order, and I want to recognize Councillor DePalo for a prayer and for leading us in the Pledge of Allegiance.
Thank you, Lieutenant Governor. Today, I just ask that we offer a moment of silence for all those who continue to suffer in the wars ongoing throughout the world. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, good afternoon, folks. At this point, I'd like to recognize Councillor Duff for a motion to record advice and consent for the financial warrant.
So move, Governor.
Thank you. Seconded by Councillor Jacobs. All those in favor?
Aye.
Opposed? The ayes have it. I'd like to recognize Councillor Jacobs for a motion to record advice and consent for the pending list of notaries public.
Sorry, that's me.
You're out.
It's always the.
All right.
Fire alarm.
Better you than the fire alarm. Okay, so once again, I'd recognize Councillor Jacobs for a motion to record advice and consent for the pending list of notaries public. So moved. Is there a second?
Second.
Seconded by Councillor DePalo. All those in favor?
Aye.
Any opposed? The ayes have it. I'd like to recognize Councillor Kennedy for a motion to record advice and consent for the appointment of Leo Fama II to the position of Associate Justice of the District Court.
So move, Governor.
Is there a second? Seconded by Councillor Ferriera.
Want to,
Under discussion, Councillor Devaney.
I've seconded, and he is outstanding. Good. You're bringing good people in, so keep them coming.
Will do. Thank you very much, Councillor Devaney. Any other questions or comments? Seeing none, I will ask the secretary to please call the roll.
Kennedy,
Yes.
Yes.
Councillor DePalo,
Yes.
Councillor Jacobs,
Yes.
Yes.
Councillor Devaney, Iannella,
Yes.
Councillor Duff.
Yes.
7 members voting, 7 in the affirmative. The matter carries. Next up, I'd like to recognize Councillor Iannella for a motion to record advice and consent for the appointment of Marjorie Tynes to the position of Associate Justice of the District Court.
Thank you. So moved.
Motion made by Councillor Iannella. Is there a second?
Second.
Seconded by everybody. Councillor DePalo. Any questions, comments, or discussion on this?
Just great.
Awesome. Thank you. Seeing none, I'd ask the secretary to please call the roll.
Councillor DePalo,
Yes.
Jacobs,
Yes.
Councillor,
Yes.
Councillor Devaney,
Yes.
Councillor Iannella,
Yes.
Councillor Duff,
Yes.
Councillor Kennedy,
Yes.
7 members voting, 7 in the affirmative. The matter carries. Next up, I'd like to recognize Councillor Devaney for a motion to record advice and consent for the appointment of Gabrielle R. Willahogen to the position of Associate Justice of the Supreme Judicial Court.
Thank you for this opportunity, Lieutenant Governor.
Can you make that motion, Councillor?
Pardon?
Is that a motion you're making this motion? Yes, and is there, just let me get a second under discussion.
Thank you for this opportunity.
Second the motion.
Seconded by Councillor Duff. Under discussion, Councillor Devaney.
For this opportunity to speak before I make the motion. In my 25 years, I have never seen such media attention to any nominee that has ever come before me. And I want to thank you, Lieutenant Governor, for the honor of co-chairing the hearing for Judge Willahogen. As her district counselor, I chair at her hearing. So 16 years ago, I chaired her hearing for the appeals court. She was the most outstanding nominee ever before me for the appeals court. She has changed case law that's 100 years old. She has a program to mentor the people, the judges coming in. There's so much more I could say about that. And I guess what I want to say is that I welcome the media, and we don't get them. And I have been asking, please investigate our nominees, report on them, come to our hearings. And it doesn't happen. And I want to welcome them, please. Okay. So I have seen in the past, but people don't know, we vote we have a hearing first, and then a week later, we have this public assembly where we vote for that person. I have been here when we didn't have a hearing for someone. 63 years we're mandated to have hearings. Didn't have a hearing. At the public assembly, council voted. I voted no. So I'm just saying, there's so much that goes on, and the media never covers that stuff. And I just want to say that this person has given so much to the appeals court and the mentors. I have never seen so many people in the auditorium, and I have chaired the highest court nominees, Judge Gantz, Judge Sossman, and others. They came, I got calls from retired judges 23 years ago, 21 years ago, someone who was in New York. I mean, these people all respected her so much and told me about how they interacted with her through the years. I never heard that in 25 years. I never got the calls that I had. Yeah, there were some people that were opposed, but not on her qualifications, on her integrity, and what she has brought to the court. She is going to be a great loss on the appeals court, believe me, because she has mentored so many people and has brought so many programs. And I just thank you for this time. And I could say so much more, but I'll bore everybody to death. But so I am going to make the motion to nominate Gabrielle Wallapogian, judge, to the Supreme Judicial Court.
Thank you, Councillor Devaney. I believe Councillor Duff has seconded that motion. Any other comments or questions by members of the council? Councillor Jacobs.
Thank you. I just want to start by saying how much I do respect and have a great deal of admiration for the many, many nominees that we've received to date. But I do want to express some of the concerns that have continued to trouble me in this nomination process. We share values, myself and this administration, around diversity, equity, and inclusion. And fully focusing on the process itself, putting aside the candidate for the moment, the nominee for the moment, but just fully looking at the process, I have struggled with a sense that the process itself was lacking in those values. In terms of diversity, my perception is that it was a very small and insular, like-minded group, lacking diversity in thought, but also in regional representation. In terms of equity, again, the regional inequity from the perspective of the councillor representing Western Massachusetts. And from an inclusion standpoint, it just felt very exclusionary in that you couldn't have a more insider nominee. And so I have concerns about that in terms of how it might dissuade people from applying who are not inside a network like that. I continue to have some concerns around the recusal situation. But I will say that I've received many, many communications. I think we all have. I've had calls, I've had texts, I've had emails, I've had snail mail. And for me, it's been a very mixed set of communications. Many people have written in support and have underscored the qualifications, but in my district, I've received as many calls and emails underscoring the disappointment that once again there's a vacuum at the SJC from Western Mass and Central Mass that is longstanding, and other concerns as well about the impact on the court's integrity, our highest court. The last thing I will say is that I don't want to invalidate the enormous qualifications of this candidate. I think it goes unimpeachably. She has a fantastic resume and experience. I do have a concern about her as well. And the concern really is from, I talked to her in depth, and my perception is that, you know, she has breathed rarefied air from the time she was young, education, and through her career. And my perception from that is she intellectualizes the marginalized community's struggle in a way that it feels very much a bubble of privilege and detached from the struggle itself. So I do have a concern about whether justice is best represented through that lens. But that is my only hesitation about the candidate herself. I'm really more coming from a place of concern around the process and the implications and the appearance that got us here today. And for all of these reasons, today I will be voting no.
Thank you, Councillor. Councillor DePalo?
Thank you, Lieutenant Governor. In my time on this council, I've accumulated more no votes than any of my colleagues. And each vote was because in the totality of the circumstances, I felt that I couldn't support the nominee. In some cases, my subjective judgment, which is of course not the objective truth, was that I've seen nominees who I felt were underqualified or unqualified, or that they were being put into position because of political favors or political fundraising skills. I never saw scrutiny or attention brought to those nominees as I have this nominee. And so the discourse around this nominee has bothered me so much. I just briefly want to speak to it. When this nomination was announced, in some corners, the public discourse jumped right over this nominee's impeccable, unquestioned experience, her qualifications, her pedigree, her temperament, her reputation earned over a decade on the appeals court, writing hundreds of appeals decisions. The narrative in some places jumped right to a salacious storyline designed to raise alarms. And on the surface level, it did. But we're not here to rest on the surface level. We are here to conduct diligence and dig deeply into each nominee's qualifications. And so, like many other nominees, the nominee came to Worcester to visit me in my office, and we had a long-ranging conversation. One of the things that I spoke with her about was my concern that we ensure that under the Massachusetts Constitution and in Massachusetts courts, we continue to uphold the rights and privileges that appear to be at risk on the national level. That is important to me because I do not want the government concerning itself with a woman's health care or her bodily autonomy. And I'll take it a step further. I don't want the government concerning itself with a woman's past, emphasis on past, relationship choices. And I'd ask, when do we stop policing a woman's body? How many years back do we have to go to stop policing women? And to those who tell me that a relationship that ended years ago should be disqualifying for this position, I would ask them, should I advise my smart, confident, and maybe one day ambitious daughters to never date an ambitious person because years later it might disqualify them from a position that they have worked their whole lives to deserve? And so for those reasons, I'm disappointed with the public discourse around this nomination, and I look forward to voting yes to support this nominee. I think she will be an outstanding justice on our SJC. Thank you.
Thank you, Councillor DePalo. Others, Councillor Kennedy.
The Constitution does not require any process in place prior to a nomination taking place. The Constitution simply says that the governor shall nominate with the advice and consent of the governor's council. The process that counts is the process that happens in this room when we vet a nominee. And our role is a very narrow one. It's to determine if the person who is sitting there is qualified for the position. The governor can nominate whomever she chooses. And then it's our job to decide if that person's qualified. I talked about all the emails and snail mails and text messages and phone calls I got about this nominee, and every single one of them felt she was qualified. The ones that had issues with it was about the process, and that was probably 1% of those phone calls. There's no question, and no question in my mind, This nominee is qualified for that job, period. Councillor Duff and I sat down with her when there were 5 openings. I knew nothing about her relationship with the governor at that time, past or present. And we encouraged her to apply some 7, 8 years ago because we thought she was phenomenal. And we were looking for diversity on the bench and somebody who was really, really qualified. And we thought that 7 or 8 years ago, and nothing's changed in terms of that. I have never asked a nominee anything about their personal life, and I never will.
Thank you, Councillor Kennedy. Any others? Councillor Ferriera.
Thank you. Because I hail from the South Coast, I asked the nominee to come down to Fall River, and she did a couple of weeks ago, and I spent hours with her talking about who she was as a person, what she wrote as decisions, what her background was. She's, we all know her stellar education from Oxford and Columbia, was editor of the Law Review and Rutgers. Then I wanted to digest her 900 opinions that she wrote. So I put it into AI and it didn't do anything for me. So I particularly asked her, because I spent 30 years in law enforcement, about decisions that she wrote involving public safety. All about having an orderly society, not a police state, but we have to be safe, because if we're not safe, nothing else counts in life. And I'm pleased to report that she sent me a bunch of decisions that she wrote. And they were fair to the police and they were fair to defendants. And I got letters written from somebody who did hundreds of appeals representing criminal indigent defendants. He never won one in front of the judge, but said what a stellar judge she would make. At the end of the day, I do believe that she's a very, very well-qualified person. The governor went on a limb to say she's the most qualified person in the state. And I thought that was a little like, I don't know. But you know what? I do agree with the governor. I think she is. When you have 25 people from the appeals court, judges, coming here saying that she's the best in their court, she's never been tipped on any decision she's ever written. That speaks volumes. So I judge her on her own merits, and whatever relationship she had with whomever is actually irrelevant, for this position. And I'm proud to vote for her today. Thank you.
Thank you, Councillor Ferriera.
Thank you. First of all, the Constitution doesn't require us to have hearings, but over 60, 65 years ago, it was established that there would be hearings, and then we would vote the next week at the Assembly. So I do want to say that I guess I probably have talked with her more than anyone. Because I talked their ears off, and this was when she came before me in the appeals court and when she came before me now. And I talked with her. She had recused herself when the governor had been Attorney General. And I wanted to know about recusal on matters now. And I was, I was completely, satisfied with her, and she is respectful and she's honest. And, and she said that, those matters she'll take up individually. And I'm not going to go over that old. But I want to say that in Governor Baker's administration, the Judicial Nominating Committee, Screening Committee found her number 1. The Supreme Judicial Court Screening Committee, number 1. The Bar Association, number 1, but she didn't get the appointment. So I think that elephant in the room is affecting why she didn't get it. And I can't think of anyone that is more qualified. And when I talk to all those wonderful judges that I respect and I voted for, and they filled that auditorium, I've been here 25 years and I have presided over that court. And I have never seen anything like this. So I'm sorry that she had to go through this. I don't think anyone should really. We're talking about 2024, and what have you done? And if you look at, and I'm not going to go through it, what she has done on the appeals court made such a change that anyone that would disqualify this person who will be so valued on that court. So I have said too much today, and that's all I'm going to say now.
Thank you, Councillor Devaney. Any others before we call the roll? Okay, I'd ask the secretary, we have a motion that's been made by Councillor Devaney, seconded by Councillor Duff, and I'd ask our secretary to please call the roll.
Jacobs? Ferriera?
Yes.
Devaney?
Yes.
Iannella?
Yes.
Councillor Duff,
Yes.
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 7 members voting, 6 in the affirmative, 1 in the negative. The matter carries. We have one other item on our agenda before us is a reappointment to the Office of Public Administrator. I'd like to recognize Councillor Ferriera for a motion to record advice and consent for the reappointment of Thomas R. Hunt to the position of Public Administrator for Bristol County.
I am proud to make that motion. He has served admirably as an administrator for many years. Thank you.
Motion's been made and seconded by Councillor Devaney. All those in favor?
Aye.
Any opposed? The ayes have it. The matter carries. And with that, our business is concluded. Thank you all.
coming. And I welcome our nominee, Courtney. And I am Marilyn Petito Devaney, and I will be presiding today. So I'm going to, I'll introduce a council. Council Kennedy. Council Kennedy. And with that, I will read the letter from the governor. Dear councilors, I am pleased to nominate Courtney Linnehan to the position of Associate Justice of the District Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am including the nominees, enclosing the nominees' resume for your convenience. So again, welcome. I first, well, they're not here, but what I first would like to say is that please put your phones away. And I ask the councils all the time if they would stay and remain in their seats for the rest of the hearing in respect to you and to the process. And so the other thing is, if anyone wants to speak, would you just stand now and take the oath, okay? Yeah. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Okay. So with that, I'm going to start with your witnesses and the order that you have given me. And the first is the Honorable Lawrence Pierce, Associate Justice of the Superior Court. Welcome.
Welcome.
Want to sit down?
See, should I be here?
Sit, yep. How long has it been now?
10 years since I first visited with you, and 14 years since since I last visited with you.
Had-
First visited.
Had both my votes.
5 years since his 80th birthday.
I mean,
And I can still beat him running around the building.
yeah, but well, you got both my votes, and you haven't been here though. You haven't come.
To testify? A couple of times through the years, but not in recent times. You're right.
That's a while back. Well, welcome, and we welcome your testimony.
Well, I am pleased to be here today in support of Courtney Linnehan's nomination to the district court. My name is Lawrence Pierce. I'm a Superior Court judge. I'm now in my second year of recall. Before joining the Superior Court, which was 10 years ago, I served as a district court judge for 5 years. Before that, I was in private practice for 20 years. And before that, I was a Middlesex DA, where I learned everything I needed to know from Councillor Kennedy.
Sorry about that.
I have been a regional administrative justice for criminal business in Middlesex County since 2016, which was soon after Attorney Linnehan joined the Middlesex DA's office. And since then, I have had a substantial amount of contact with her, mostly in 3 types of proceedings. The first, in the first criminal session in Woburn Superior Court. That's the session where cases are managed until they go to trial. Second, Attorney Linnehan has been in my session in an effort to resolve cases short of trial, which of course is a very important part of the business that we do in any of our criminal sessions. And finally, Attorney Linnehan has tried cases in my session through the years. I will add that over the years, Attorney Linnehan has handled among the most serious cases in the county, the ones requiring the most detailed attention, the ones requiring the most sensitivity. Many have been sexual assault cases involving both adult and child victims. So going back to the first session, I have observed that Attorney Linnehan is liked and respected by her colleagues and court personnel. Her relationship with opposing counsel is courteous and professional. The positions she takes on discovery motions and scheduling are reasonable. She is solid on the law, stands firmly where that is appropriate. Plea negotiations, as those of you who are in the business know, that is an art form, and it's one that Attorney Linnehan is skilled at. She appreciates that cases are more than numbers on a page. The victims are real people. The defendants are real people.
From a judicial perspective, the plea negotiation process involves a lot of factors: the nature of the case, the defendant's record, if any, harm to the alleged victim, the views of the alleged victim, penalties, defendant's background, the defendant's particular involvement in an alleged offense, any mitigating circumstance. On top of that, a court is required to layer on how other similarly situated defendants were sentenced, filtering out, of course, implicit bias along the way. So there's a lot going on. After that, you look at the recommendations of the parties, and sometimes you conclude that one recommendation or the other is appropriate. Other times you find a place in between the two recommendations. The point of all of this is a process that, if confirmed, Attorney Linnehan will be able to undertake effectively, given the vast amount of experience that she has in the trial court. For a less experienced nominee, there would be a steep learning curve in this regard. Attorney Linnehan is not vindictive or harsh. Her positions are thoughtful and balanced. I remember two recent pleas that she did in my court. First, in 2021, it was a rape case where the defendant pled guilty to an indecent assault and battery. In the second case, last year, I believe, the defendant was again charged with rape, and during the pendency of the case was diagnosed with schizophrenia. Attorney Linnehan and defense counsel undertook a long plea negotiation process, which involved the provision of mental health treatment. At first, I was skeptical. This was a serious case involving a stranger victim, but what she was able to accomplish was to convince me that this was a disposition that was good for the victim, it was good for the defendant, and it was safe. It was safe because the defendant was not going to be on the street without supervision. ADA Linnehan has also tried two cases in my courtroom, the first in 2018, the second in 2021. Again, both were sexual assault cases. ADA Linnehan is an experienced and a skilled litigator. She is comfortable in a courtroom. She understands the prosecutor's function, of course. She has been one for a long time, but she also understands and appreciates the defense function and the court's proper role. She is clearly not afraid to make difficult decisions, and she does so in a calm and a dispassionate manner. She knows the rules of evidence. She is well prepared, has realistic expectations. In the life of a case, she fights the important battles, not those that are less consequential. So simply stated, I believe Attorney Linnehan has the tools to be a superb trial court judge.
Thank you. Before I call on the councils, I want to introduce the people, the councils have joined us. Councillor Ferriera, Councillor Duff, and I've already introduced Councillor Kennedy, Councillor DePalo, and Councillor Jacobs. So having said that, go away.
Okay.
Does anyone have any questions for the judge? Well, did you?
Oh, no, I just respect the fact that he's the first man to say that he learned something from Councillor Kennedy. So,
I wanted to say how we have to change that 70. And I'm trying to find someone to do it. How crazy is it? He can be a recall judge, he can be 75 and be a recall judge, but you have to retire at 70. If that makes any sense to anybody, I don't know. But anyway, but
Well, thank you.
Now tell me, what case really comes to mind that impressed you the most?
Well, I suppose, you would think the trials, but it was really the last plea that I refer to, which was a very difficult negotiated disposition of a case with a victim who really didn't want to go to trial, but with a defendant who needed services desperately, and finding the tipping point in resolving a case like that is not so easy, and she did a wonderful job.
So there's no questions, I guess that's it, but thank you so much. Your testimony means a lot.
Good to see you.
It's been a while. Our next witness is the Honorable Marion T. Ryan, my Middlesex District Attorney from Woburn.
Thank you.
Thank you.
Thank you for giving me this opportunity today to talk a little bit about what I believe will be an excellent fit for the district court, and that is the nomination of Courtney Linnehan. You will hear, and I know you know already, and I really want to start by thanking the members of the council. People see this hearing, but what we all appreciate is the hours that go into the preparation that you have done for this hearing, talking to the nominees, reviewing their credentials, talking to other people about that. And as someone who practices in the courts, I am grateful for that. You will hear and already know a lot about many of the things that you're considering for Courtney. You'll hear about her broad range of experience, her great trial skills, the relationships that she forms with people on both sides of the aisle, and that is borne witness to today by the members of our office, defense bar, members of law enforcement who are here with us. But I want to take my few minutes to focus a little bit on probably lesser thought of qualities that I think make a good district court judge. There is an essay that talks about what happens or what causes judges, prosecutors, or lawyers to not do a good job. And it says it's not because they're not smart or they're not good people. It is because they just get used to the job and they get used to everybody who's in front of them being the same. That's not going to happen with Courtney. Courtney is someone who sees people for who they are, who realizes and is comfortable in her own skin, knowing that she has had certain privileges in life, privileges that other people have not had. So that makes her able to learn about other people, to evaluate evidence, to think through what the result needs to be. Very importantly, and for those of us who are lawyers, we all hope the judge rules in our favor, but at some point you need the judge to make a ruling, and Courtney's able to do that. She's able to make a decision having gathered all of that information. Those are qualities that I think contribute greatly to a successful district court. District court is really important because you are so close to the action. You are seeing people sometimes just hours after something terrible has happened to them. We share that intimacy, I would suggest, only with medical professionals and religious leaders in seeing people at their worst. And when you do that, you have to see the individual. I've seen it in the 8+ years that Courtney has worked for us. She sees behind the name of the case to the people and what they need. She's comfortable evaluating that case and coming to a decision and standing by her decision. And even when, as you heard from Judge Pierce, the court might be thinking, I don't know if I want to do that, she's very comfortable in doing that. So I am delighted to be here. I am fully confident that she will be a wonderful addition to the trial court.
Any councilors have any questions?
No, great to see you.
It's good to see you.
I'd like to just say, you're almost a neighbor of mine. I'm in Watertown in Belmont. I just want to say how proud I am of you. We all are. And I can't remember so many dangerous, serious cases that have come up in the last year or so that you've had to, I don't know how you sleep at night, God bless you, but I want to thank you for that. So tell me, what do you think is the greatest quality that this nominee brings to the court?
Without question, it is curiosity. I think curiosity is what makes a good lawyer. It certainly is what makes a good prosecutor, and I think it's also what makes a good judge. It is that ability to be, as I mentioned, comfortable enough in your own skin to make inquiry about things, to see people for who they are, to be willing to learn about things. I've seen that with Courtney in her cases, with the 250+ people who work in our office. Courtney knows lots of things about people. She gathers information, and that helps to make informed decisions.
Well, thank you. I think this is the first time that you have come before us. That's
A long time.
Right, yeah, because I've been here 25 years. So thank you so much. Your testimony means so much, and that really is wonderful that you come and talk for her. You're the boss.
It's a privilege.
Thank you. The next witness is Craig Mulcahy. I'm not going to have any trouble with Irish names. I might said it right.
Thank you very, very much.
Thank you.
It's an incredible honor to be here today, and I'm very grateful for all the attention that you all have given to, I know her as Courtney. Some of you may know her as the nominee or ADA Linnehan, but Courtney's my friend first and foremost, and that's how I've always referred to her. And she's talked to me about this process and meeting all of you and speaking to you, going far away to meet some of you, and all of it's been incredibly enriching and helps me understand and appreciate the process for the people that I go before every day. Courtney and I met in the year 2000. We were assistant district attorneys together in the Dorchester division of the Boston Municipal Court. I don't think it was quite yet the division of the Boston Municipal Court yet. That developed sometime later, but we were together in the basement DA's office. We had 2 desks mashed together with 1 computer and 1 keyboard, and we shared that to do all our work. Courtney came from North County as well. We crossed paths very briefly in our movements career-wise, but we didn't know each other in Norfolk County. I got to know her in the Dorchester court, where you get to know people very quickly because of the intensity, the activity that goes on there. And as we just heard from District Attorney Ryan, we did see people at their very worst, often, if not hours, sometimes minutes after they'd been peeled off the street or dragged from some location because of an allegation or an incident that occurred. And what I learned from Courtney during all those experiences was how much care it took to read a police report, and not just to read the words on the report, but to make an assessment of the situation, to take the situation in as a whole, sometimes in as little as 15 minutes, but often with a lot more time. And starting with that foundation, you could then build your theory of the case and what you thought was the right thing to do. And in all my experiences with Courtney, she's always done the thing that she knew to be the right thing to do. And ultimately, I don't think anybody could ever quarrel with that decision. You might not, you might have wanted to do it somehow differently, but the ultimate outcome, I think, was unequivocally correct. And one of the things that I think of when I think about Courtney is her decency. We heard some of that already. She wants to know about everything, not just what happened to the alleged victim, but what's the circumstances of a defendant. She was a defense attorney for a time. She was a divorce attorney for a time. She taught me how to be a divorce attorney. She taught me in many ways how to be a defense attorney. And she first and foremost taught me how to be an assistant district attorney. She's a teacher, she's a mentor, but first and foremost, she's a friend. And I can't think of anybody who'd make a better impact on the district court than somebody with her talents and attention to detail.
Thank you. Any questions from the councillors?
Oh, good to see you.
I'd just like to ask you, is there any case that you worked on that you will always remember and that it was really meaningful?
Yes, I can tell a story on myself. One day in the Dorchester court, I showed up in street clothes because I thought I had an office day. In fact, I had a trial that involved a victim, and no sport coat and no tie. I briefed the case with Courtney for about an hour. She went up, she tried the case and won. And the guy was found guilty. There's another case that I think is important to talk about. She's had all kinds of victims, all kinds of people that she's trying to help. One of the cases that she was working on in the last several months involved a victim with special needs. And she had talked to me about her efforts in working with that person so that they could explain the situation, what happened to them. And it's one thing to do that in an office and in the comfort of an environment where everybody's kind of your friend and everybody's kind of on your side. And what moved me about that experience for Courtney was her efforts in helping that person appreciate the much more imposing reality of going into a courtroom and actually telling her story. And as far as I know, Courtney was able to move that person into that ability and for a successful prosecution. That's all I really need to say about it, to give you all the impressions that you need to make this nomination what it should be, which is permitted to go through.
Thank you. Your testimony means a lot. Thank you for coming.
It's great to be
So
here.
that concludes our witness list. Oh, I'm sorry.
There was another young lady that wanted to speak that's not on the list.
Oh, I'm sorry.
I was waiting until you called for anyone else to come up.
Okay, would you like to sit down and tell us your name? Thank you, Councillor.
Good afternoon. My name is Karen Goldenberg. I am
I'm sorry, what is your name again?
Karen Goldenberg. I decided to come today and talk about Courtney because I think it's important for all of you to hear from opposing counsel. I've been a criminal defense lawyer for over 20 years. And I have tried cases against Attorney Linnehan. Specifically, we tried an aggravated child rape case, and we until recently were opposing counsel on a first-degree murder case. And I am hoping that Ms. Linnehan will not be working for the DA's office by the time that goes to trial. She has a new job, hopefully. I believe that Attorney Linnehan is exemplary, both as a lawyer and as a person, and will make a fantastic addition to the district courts. A prosecutor has a very special role in litigation. The other lawyers who are trying to win their cases, they have an obligation to do justice. And Attorney Linnehan does just that. She's very forthcoming with the weaknesses in her case, with exculpatory information. And I never had any concerns in cases with her about something being kept from me or fixed in a way that it shouldn't have been fixed. I also wanted to mention that Attorney Linnehan is a very kind and compassionate person. We were opposing counsel on this child rape case for several years. There was a delay because of COVID-related foreclosures. And during that time, my mother died, and it was awful. And Attorney Linnehan not only assented to all the many continuances that I requested, but she was also really supportive. She had gone through the same thing a few years earlier. She was also dealt with a father who didn't really know how to be without a wife, and gave me a lot of advice on how best to deal with support my father. Very appreciative of that. I still am. And I hope that all of you will vote in favor of Attorney Linnehan. She's exactly what the district court needs, a person with integrity and great character. Thank you.
Thank you. Any questions?
Thank you.
You're being quiet today. I just wanted to say that to have an opposing counsel, that means a lot to me. That you went out of that court. I don't know who won the case, but you had respect for her. She won. Okay, that you had respect for her. And I think that's the most important thing, whether you win or lose that case, to have respect for each other. So your testimony really means a lot to us. Thank you so much for coming. Yeah. Now, is there anyone in opposition? So having heard none, oh, I forgot to introduce Councillor Iannella.
Good afternoon, how are you?
Do you have any questions, Councillor? So this one? Yeah. Okay, so having no opposition, now, first of all, I'd like you to introduce all the people that came here for you.
You've met all of my witnesses, and you met Attorney Karen Goldenberg as well. I also have here my husband, Abdel El-Meme, my sister, Shauna Wood, my mother-in-law, Roger Wood, my dear friend, Kimberly Pastor, and then I have a couple members from the Middlesex DA's office, Joanne Cito and Megan McDade. Then I have Lieutenant Blaise Tersoni from the Framingham Police Department, Detective Darren Crawford from the Framingham Police Department, Judge Michelle Armoire, and my friend Ann Yaz, who I've known for 25 years, maybe.
Wow, that's great. Thank you all for coming. Now it's your turn to make your presentation.
Good afternoon, members of the Governor's Council. I am honored to be before you today as a nominee to Associate Justice of the District Court. I want to thank Governor Healy and Lieutenant Governor Driscoll for their confidence in nominating me to Associate Justice of the District Court. I also want to thank the Governor's legal team, Paige Scott Reed and Dara Kesselheim, for your guidance throughout this process. Thank you to Valerie McCarthy and her team. Also, thank you to the members of the JNC for their consideration and support. Most importantly, I want to thank my husband for everything that he has done to support me over the past several weeks, and especially, or I should have said over the past few months, especially over the past several weeks. If I am fortunate enough to be confirmed as a district court judge, it will be my job to ensure that people are treated fairly and with dignity, and to help people address the underlying issues that have brought them into court. I would like to share with you briefly a few of the personal and professional experiences I believe have prepared me to do this job well. I am fortunate to have had a comfortable childhood with a supportive and loving family. In many ways, my upbringing is unremarkable. My parents, however, were remarkably insistent that I experience as much of the world around me as possible. My parents encouraged me to always try new things and experience firsthand the different cultures around us. They taught me that there are so many different ways to do things, and I should always be open to new experiences. Sometimes this was as simple as trying a new food or attending a religious service with a friend's family. When an opportunity presented itself in high school to spend the summer in a culture vastly different from where I was raised, my parents made sure I was able to do this as well. My parents' insistence that I experience everything at every opportunity has in many ways shaped who I am today. Along the way, I met people who were very different from me on the surface. I saw poverty I never imagined. I got to know people who spoke different languages, who wore different clothes, who ate different food, and who thought about the world in different ways than I did. But my parents always told me that people are the same underneath the surface, regardless of how different they may appear on first impression, and to remember, no one's life is easy. Those early experiences and my parents' message have stuck with me and shaped me who I am as a person and as an attorney. I have spent my career representing or trying to give a voice to individual people. I worked as an attorney in my own practice, representing individuals, often defendants. I have worked for many years as a prosecutor, and much of my work has been focused on giving victims a voice in court. The people I have represented or tried to help are very different on the surface, but underneath, in many ways, they are the same. And whether working with victims or working with people accused of crimes, I've always started by trying to find commonality. Even though my life experience may be different from theirs, there is sameness in the experience of emotions and often the experience of loss. Finding commonality has been the first step in being a good attorney for my clients and has prepared me, I believe, to be a good judge. Often victims or clients assume that I will not understand what they are going through because I'm an attorney or because my life has been relatively comfortable. But I have been able to draw on the events of my own life and the values my parents instilled in me to relate to the hardships that they are going through. No one's life is easy. My life has had some challenges. I lost both of my parents at a relatively young age. My husband is an immigrant from Jordan, and English is his second language. He is frequently treated differently than I am, based on his accent, his name, and the color of his skin. I have been able to use the experiences in my life to empathize with victims and clients who are often experiencing much harder challenges when they come to court. One of the reasons I particularly want to be a judge in the district court is because in the district court, people experiencing hard challenges are often given a second chance. The judge has an opportunity to guide them onto a path or into a treatment program where there is hope for redemption and rehabilitation. As a judge, I would work hard to understand the underlying issues that brings a person to court. I would value the chance to help them find the way to address their underlying problems, so they would not get stuck in a cycle of committing crimes based on mental illness, substance abuse disorder, or any other underlying issue. When people have the opportunity to address the underlying cause of what brought them to court, the community becomes a safer place. I believe that my professional experience of understanding the perspective, not only of a victim, but also that of a person accused of a crime, will make me a more compassionate judge. If I am fortunate enough to be confirmed as a district court judge, I will draw on all of my experiences, both personal and professional, to ensure that the district court is a place where people are treated fairly and with dignity, and where people are given an opportunity at a second chance. Thank you for giving me this opportunity to address you today, and I look forward to answering any questions you may have.
Thank you. Councillor Iannella, questions?
Very much. District court is a community court. In your community, wherever you live, are you involved in any activities or programs?
I have been, and for a number of years, I was a member of the Milton Junior Women's Club. That's an organization that brings women who live in the town of Milton together. There's a road race that they have every year, and the funds raised from the road race are then used to provide scholarships to kids graduating from high school, and to help them fund college and purchase books. During the pandemic, I actually stopped working in that particular organization, but I did that for a number of years.
Okay. I know Milton does not have a district court. Located there, so the closest one is this one. Milton, do you go to Quincy or do you go to Duff?
You go to Quincy.
So you're confirmed. And now you have, a low level. So-and-so's in front of you. And they're from Milton. They're not your best friends, but you know of them. You know the defendant's parents. That's really respected people in the community. And you've met them on a few occasions. You're human. What do you do in a situation like that? Do you recuse yourself, or do you, let's just they want a bench trial? What do you do in that situation? Because it is awkward.
Right. So I think depending on how well you know
Your best friend, see you at a couple of social events in Oakland. Oh, I have Joe, but you haven't gone out to dinner with him, but you clearly know that, and they know you.
I think in an instance like that, it would be very important to disclose that to the parties involved in the case. Disclose your relationship, give both parties an opportunity to state on the record if they have any concerns about that, and then ultimately the judge has to decide on whether they feel that they have a bias that would interfere.
So, let me ask this, well, it could be either one. Say the NDA says, I'm punchable. Like you yourself. What do you do with that?
I think if one of the parties is uncomfortable with it and requests the judge to recuse themselves, it seems to be the more prudent decision. You don't want to be in a position where you may have a bias.
It's awkward. You don't want to be put in that position, and 2 weeks later you're seeing them. Who knows what would happen? I do agree. I've always thought, and I've been on the council a few years, that once a prosecutor, and we talked about this, always a prosecutor. You've been a prosecutor on and on, 15+ years.
Yes.
I'm a perfectly, no question. If I was a judge, as much as I'd say, oh, I'm going to be fair, I'm not worried. It tend to be, in my situation, pro-plaintiff, pro the injured person. And it's hard for me to believe, and they all say, oh, not me, don't worry, I'll be here. Oh, but in reality, what's your thoughts?
So, well, I think being a judge is very hard to begin with. But to answer your question specifically, you're right. I have spent more of my career as a prosecutor than I have in doing civil or as a criminal defense attorney. But I have done both. I have sat next to an individual at trial on a life felony case. And I have, worried about the outcome in that case and would my client, potentially go to jail for up to life. And I would take that experience with me. I do take it very seriously. And I have sat in Superior Court next to people who could be going to state prison for 15 years, 20 years, or life.
Yeah, but most of the lawyers that I talked to, over the years, oh, what did you confirm so-and-so for? Didn't you realize it was an ADA from Norfolk? Totally. I hear that a lot. I mean, to me, the ideal candidate for a judgeship is a sole practitioner who's done, I don't care if they've done criminal or civil, but a sole practitioner. I just feel like it's so hard. You're a prosecutor. It happens all the time. I hear stories all the time. Oh, bail. Are you gonna be able to bail? Like, you're not gonna be a rubber stamp for the prosecution?
No, and one of the things we talked about when I spoke to you on the phone is we talked about it's not that recent, but it's a fairly recent SJC decision and the mandates it has for a judge to set bail, a reasonable bail, a bail that a person may be able to meet. And I have seen judges, ask, defendant, how much money do you have in your pocket? How much money could your family make? Do you think you could raise that money in a week or 2 weeks so that the bail is set at something the person can make and they won't be held without bail for a year or more pending trial?
So in a hypothetical where someone has what I would consider medium criminal record, not like 10 pages, medium. And his attorney, able attorney, Councillor Kennedy, so he's one of the most esteemed defense attorneys in the Commonwealth. He comes and says, the guy's got no money. He can only, in his family, his father lost his job, and they're struggling just to pay the bills. All he can come up with is $100. And if anything more than that, he's gonna be in jail for a long time. Yeah, we know some assault and battery, but no one was hospitalized, but it was assault and battery with, with a screwdriver, okay? And the ADA is saying, I'm gonna follow the statute, I have, decision. I think it's reasonable, $500. You're a Kennedy, what are you gonna do?
If the person, as you said, has I think your word was moderate record, they're a member of the community, it sounds like. And if they don't have any defaults, it sounds like $100 is a reasonable bail for that particular person.
I mean, I don't do criminal work, but I totally believe, disrespectful. That's hard for me to believe, that all these APAs, 500, no. Kennedy says 100, I'm going 100, that's reasonable. This one here, yeah, I'm going with it. I don't know, man, I totally believe you, I respect you. It seems to me, it's hard to believe. I mean, it seems unrealistic. And why do I say that? Because I think a lot of judges, well, it's real. A lot of judges are afraid of the newspaper. Okay? And they're afraid of the newspaper. You let them know $100 cash bail. The assistant DA was looking for $500. Guess what? Operating under, and someone is seriously injured. This right here, Linnehan, let him up too early. We never should have let this guy out. Are you concerned about that?
So I think as a judge, it's important to look at all the facts and circumstances. As you said, You mentioned his record, the facts of the case, whether they have faults on their record or not. And something that I think you and I talked about on the telephone, what is a reasonable bail for one person in one community versus a reasonable bail for another person may be vastly different, and it might be a high bail for some people to come up with dollars.
And don't you agree that a Judge Linnehan has to think that this bail is reasonable, but Judge Farrell over here, that bail is ridiculous. So you always want to have that situation, right? So, yeah, I think it's, I used to do it when I first started, I used to do court-appointed work. And I was in this court, that court, long story, but I felt that things have changed. A lot of people want to form this. But I think stop. But I think most people, 95% of the time, the judge would follow the recommendation of the ADA, the bail situation, and defense recommendations. What are your thoughts on that?
So my experience, both as a defense attorney and as a prosecutor, going back to when I started in district court, and I do want to add, I started in Dedham District Court, and a little later I went to Dorchester, and a reasonable bail in Dedham and Dorchester are miles apart. But in my experience, I have found the judges I have been in front of have listened carefully at bail or at sentencing to the facts of the case, the position of both parties, and that I feel that most of the judges I have worked with do not always come down with the prosecutor.
Okay, we should follow up on that. Let's your case, you're sitting in Dedham, and then next week you're sitting in Dorchester. There's, I don't know, actually staff, but there's a lot more crime in Dorchester. Are you giving those people, which would be, I wouldn't like that, because there's a lot of people, there's a lot of minorities in Dorchester, represent Dorchester, represent that. Are you gonna give them a higher bail?
No, it would be based upon cases that have indicated. I think a reasonable bail in Dorchester is going to be significantly lower than a reasonable bail in a different community.
Okay, you have a situation, you're in Dedham, and what you think. Then you go to Dorchester, you go there for a month, the chief or the head judge in Dorchester, I'm sure the terminology says, we have, because this used to be way back when in Quincy, where the judge says, I think the judge Kramer, Kenneally, but Kramer used to say, any operating on this is what you got to do. I'm the head, the chief in this Quincy District Court. That's what I want everyone to come in. The judge was saying, the money would follow suit. What would Judge Linnehan under that situation?
I would evaluate each case separately. Given the charge, I would look at the person's ties to the community, any history of defaults, and what amount of money is reasonable to them, and make a decision that I felt was appropriate.
So he wouldn't follow the court rule, I'll call it, from the chief of that group.
I would follow the laws of the Commonwealth.
Okay. What do you do in this situation? You're in work. The case is continued until today, and you're the judge. They call the case, no further continuance. Perfect. And now, I'm going to exaggerate here, I'm sure they don't do it. Under no circumstances, no further continuance, this has been on twice before. What are you doing? Are you going to follow that? You can say, hey, I don't care about what the previous judge says, I'm doing what I want.
I think that it's important for the judge to consider what's on the docket, but then you also have to look at the parties in front of you. If somebody is asking for a continuance, you have to look at the reasons why they're asking for a continuance. Is somebody in their family sick? Has somebody in their family recently died? Sure.
Overall, well, he's. The attorney says, you know what, I was on trial last week, you know, today's Tuesday. I got off the trial Thursday. I haven't had a chance to fully prepare, and I don't think I can give my client adequate representation. But remember, this has already been continued a couple of times. What do you do on a situation like that?
If an attorney indicates that they are not adequately prepared for trial because they were on trial, it's important that their client have the best possible representation, and I would grant them a continuance.
I like that answer, but I gotta tell you, in reality, that doesn't happen.
Sorry.
I think I told you about 3 instances. Okay, listen to this, folks. I don't even care, it's my office. Okay, one of my lawyers, his wife was due, I don't know, April 5th. Case was out, wherever, I'm not gonna tell you the judge's name. It was on for April 12th. Judge, I need a continuance, my wife is due, she's you know, late or early, if you get the case. No, let us know if baby comes early or late, whatever, but he was furious, rightfully so, because now he's gonna prepare, he doesn't know when. What are you gonna do in that situation?
I would grant the continuance. I think it is unfair to put that attorney in a position where his wife is on the verge of giving birth. He's preparing for a trial when he has the birth of a child also on his mind, and continuing a case for a month or 2 and allow him the time to enjoy the birth of his child and be prepared for trial. There's probably another case that can go to trial that time.
These are real stories, I'm not making them up. Then there's another, one of the other lawyers on the council had a case, he wanted to go on vacation. Think about that, you guys go on vacation, vacation. I'm not gonna say it exactly, but, you know, on Monday, so he says to the judge, I need a continuance. You know, I'm taking my wife on vacation. Well, don't you have another lawyer in the office who can handle the case? And the attorney goes, oh, it's just me. And even this person had other people in the office. The defendant hired this person. He doesn't want you or me. But these things happen. Finally, because it was a while ago, but the bottom line, it was a hassle. He had to go to the court a couple of days before he's got to go on vacation in person, not Zoom, and finally the case got continued. But that's a lot of work and to me unnecessary. Your thoughts?
I agree with you. As I said to you when we spoke on the phone, one never knows when your last vacation is going to be. And I think it's important to respect the parties' family lives, vacation schedules. If something comes up and you have a wonderful surprise trip, the case can be continued.
She remembers, we talked, that was the other one. Imagine this, imagine this. Yeah, she's smiling. I told her, I asked, someone was sitting in that chair. I asked, what are you gonna do? If your spouse says, oh, I forgot it was being a woman, right? We're going on vacation. What's today? Today's Wednesday. It's Monday. This is all exciting. He's going to Bermuda. What would you do? No. You're supposed to know about the person's work schedule. Never should have made a reservation without going over the, you know, the plans with the spouse. I mean, that's crazy, but these things happen. I don't make these up. They're all true stories. And again, I'm gonna call you if you do it.
Please do.
But no, these are crazy things. And always remember one other thing. You've been an assistant DA. And as an assistant DA, you don't care about the rent. It's not your problem. You don't care about the lights. It's not your problem. You don't care about the secretary. Not your problem. You go on and on. Remember, an assistant DA, if you're not there, you can get someone else in the office to handle it. But that sole practitioner can't. And that sole practitioner is gonna make a livelihood, because he's got kids going to college, or he's got kids he's gonna get sports equipment for. So I hope you're gonna be cognizant of that fact, because it's a tough world out there. And you never know where your next dollar is gonna come from. I hope you'll remember that. Well, thank you. We had a nice conversation. My good friend, the clerk of the BMC, Dan Hogan, called me. Speaks volumes. He thinks you're great. And when your name comes before the council next week or the week after, I'll be more than happy to support you.
Thank you, Councillor Iannella. Councillor Duff.
Thank you. Great to see you. Two questions. LGBTQ kids, people, do you have much experience working with this community in the courts?
So I do actually. First off, I would say it was about 17 years ago. I tried a case, I was an ADA, and it was a sexual assault, and the victim was transgender, serving a sentence at Nashua Street, which is a male facility, but identified as a female. She had to be transported to court every day. I filed a motion asking the judge if she could change before testifying, and not just change out of a jumpsuit, but actually change into clothes that she wanted. For example, we had a sweater and a pair of pants, but that she could dress as a female because that is how she identified. So that I had that experience many years ago. The judge did allow me to do that, by the way. Additionally, I work in the child protection unit, and many of the kids who come into our unit are part of that community. Many of them are transgender. I've seen children come in for their first interview, and they may identify as a female. You go to get ready for trial, and they identify differently and have a different name.
Thank you for that. And I'm glad you have the experience. What is disturbing to me, and the reason I ask it, is because there is so many of these kids in our criminal justice system. And the reasons why are not good reasons. In my experience, you know, I'm not where you sit, or Marion Ryan, who I have the utmost respect for, but you know, some of them are not welcome at home. They don't feel safe at home. They don't feel safe in a foster home, or they've been abused, sexually or otherwise. And sometimes these kids end up on the street, where then, you know the story. We've seen this movie, right? The drugs, the violence, the prostitution, the crimes that happen. And they end up in this gerbil wheel in our system. And, you know, I get sick of hearing myself sometimes, but as I've said many, many times before, it's hard for a lot of people to get their heads around this particularly transgender issue. But from where I sit as an adult, and as someone who's been elected into this position, I should be held to a higher standard, as you are as attorneys and ADAs and as judges, that we're here to protect the children. And that was the word that you used, is that these are children. Thank you for that, because I think I think that's what folks have to remember more than anything, is the children. And it's our job, no matter what path they're on, wherever they go, it's our job to make sure they're safe. Second category of folks, and you and I spoke about it, personal to me, but also, you know, folks that I think are very vulnerable, are folks who may be, as we used to say, on the spectrum, intellectually disabled in some ways, but particularly those who could come in front of you and you may not know by looking at them that there's some disability there. You may have, as ADAs, you know, had experiences where you have conversations and everything seems dandy and it's all going fine, and then all of a sudden, you know, you're in the middle of a hearing or something, you realize this something's not what I thought it was. And so I before I ask you about, my question is going to be same thing, experience with this. I do want to say, I think our courts and our chiefs have done a tremendous job of trying to educate and starting to educate people about these issues. As I said to you, and I've said to others, it does not absolve you from a crime if you have an intellectual disability or a special need. But it should impact how you're treated in the court and what the sentence is. So anyway, could you speak to that?
Absolutely. I agree with you. I think the courts, I should say, have come a long way in accommodating to appear in court who are on the spectrum or who have any number of disabilities. I think we can always do better. I think the courts have also gotten better dealing with victims or witnesses who also need accommodations. My first Superior Court trial was a sexual assault involving a young man who was disabled. I have had many cases with victims with disabilities and have asked the court to accommodate them, whether, it's taking more breaks for them. Sometimes a person may need a microphone because they're so soft-spoken. And what I've tried to do is find out as best as I can what they need and ask them to tell me what they need.
Yes.
Sometimes they can't, and I have to do the best I can to say, gee, Your Honor, I think they may need this. Can we do that?
Thank you for that, because again, our job is to protect them and to serve justice, not just punishment, but justice in that there is a line between them. And sometimes the line intersects and sometimes it doesn't. But, and I think our last, one of our last frontiers, although everything changes so quickly right now, is, people with physical disabilities. Our facilities, jails, prisons, courthouses, accessible? And the one thing I know for sure, as a person who is now officially middle-aged and maybe getting a little closer to the not middle-aged, older, that I will be considered disabled at some point, either for my vision or my hearing or my mobility. And, it could be my intellect too. But these are real things, and again, it's not other, it's us. And so just that awareness, and I know, that's, to me, this is a real tough one, because I know some of these buildings aren't as accessible, and I know we don't have the technologies in all places to make them as good. But just knowing, that's step one in it. So that's my dissertation on that, and I have no further questions. Thank you, Madam Chair.
Thank you, Councillor. Councillor Kennedy?
I don't have any questions. We spent a lot of time together. Through this process as well as in the courtroom. I know how qualified you are.
Thank you. Is that it? Okay. Thank you, Councillor Kennedy. Councillor DePalo.
Thank you, Councillor. Thank you. I do. Good afternoon.
Good afternoon.
We had a good conversation.
Yes.
Councillor Kennedy told me to be extremely difficult on you. It's not always my style, so I'll do my best. Whenever a nominee has overlapping experience with me, however minor, it's very helpful for me because I understand it, and hearing their perspective on it helps me understand how they approach things. So this morning we had a nominee who unfortunately had done asbestos work, and unfortunately I had as well. It was very helpful when I spoke with him to hear his perspective on it. So all I did was spend a summer there, but I was in the Suffolk DA's child abuse unit. And I hope that my supervisor at the time, Nancy Hathaway, ends up where you are in that very seat someday as well. But that was a very eye-opening experience for me, and it really kind of changed the trajectory of my professional and personal life. I'm wondering, how did your experience, and you've spoken a little bit to it, and I don't want to hear the details of horrific child abuse, please, but I would like to know how the experience, seeing what you saw, how it's impacted your approach to things since then, if it has.
Oh, it absolutely has. I think, given the work I've done, with children, who have been physically or sexually abused, so much of that happens in private, and it is not often that those people come forward. And I like to think in my day-to-day life, I take into account that you never really know what another person or another family is going through. And also, you know, in my experience as an attorney, even though I'm currently a prosecutor, I don't know exactly what a person accused of a crime is going through. I don't know what their history is. I don't know if they've also been a victim, if they have a trauma history. So I think everything that I have learned over the years, I try to take with me, not just professionally, but also personally.
And you probably would agree that folks who've been victim of trauma aren't forthcoming always, right? Especially in an intimidating context like a legal proceeding, whether it's just meeting with a lawyer or whether it's in the courtroom. So, I mean, it seems an impossible task as a judge to be able to know these factors when you're exercising your discretion regarding a particular defendant. Is there any way to get to?
So I think as a judge, you often rely upon the attorneys to provide you the information in a criminal case, whether it's the victim or the defendant. You really rely on them to provide you the background of this person. There may be some information that you may know as a judge where you're able to ask the attorney, I would like more information about this. I'm concerned that your client may have, you know, a trauma history or have come from a family life that was somewhat difficult.
If I could interrupt you. So I would imagine with your expertise and the resume you have that you are sensitive to identifying when someone is reacting out of a place of trauma. Would that be fair to say?
Absolutely.
It would be in your discretion if you felt that way to hold an evidentiary hearing should you desire.
Yes.
Before making a disposition, would that be true? Or before crafting a?
So I think a judge often has as additional tools other than just asking the attorney for more information. A judge has the ability to ask for an aid in sentencing, which can be done by probation. Sometimes depending on what the individual is saying, maybe it's more appropriately done by a mental health professional. But something like that can be very helpful to a judge in fashioning a sentence that addresses the concerns of that particular person.
I just want to ask one more thing because I don't practice criminal law, but I talk to folks who do. And one thing that folks have been talking to me a lot lately about is the use of GPS and whether or not it's being overused in some cases where it's not actually a targeted tool to the particular situation or defendant. To take it to an extreme example, I've been told of situations where folks are being held for want of a GPS unit to attach to them. I'm wondering what your perspective is on that, because I don't purport it to be pervasive, but I do hear it, and it's on the margins where our excellent court system should be paying attention, right? Because we do good in so many areas. So what's your perspective on that?
So I have heard that as well. I have heard about people sitting in jail waiting to get a monitor like you have. I have also had cases with defendants whose monitor is broken, and the closest court that they can go to could be a half a day's drive, and they don't have a car to get there. So I think where GPS, where the court orders a person to be on GPS, the judge has to consider the law, because under the current decisions, GPS is being imposed both pretrial and post-conviction, fewer and far between. But if it is a case where GPS is ordered, it is appropriate, I think it's important for the court to recognize that not everyone can get to a courthouse to get a new beacon or device within the time where warrants sometimes issue, and unfortunately they get arrested and held.
I'm not gonna ask any more questions. I appreciate your temperament, especially based on people I've spoken with, and yeah, I've appreciated your attention to the particular nuances of people. So thank you, Councillor.
Thank you, Councillor Jacobs.
Thank you. Good afternoon.
Good afternoon.
It's good to see you.
Good to see you too.
I want to start off by saying how much I appreciate that you came out and the time we spent together. And I'm pretty sure that your husband was your driver. And so I thank you for being the supportive co-pilot in making that happen. And we had a really great conversation that was broad and far-reaching. I'm going to start from where I started with that conversation and just say that I'm fairly new to this, and so, you know, others may not have been quite as startled, but your cases are just so intense. Like the number of just very difficult to read cases in your application just sort of set me back. And so I can only imagine experiencing, you know, it on either side of the aisle when, you know, as a prosecutor or if we're doing private work, being personally invested in some of these cases. But I would like to give you an opportunity to speak to it, but my feeling is that coming from that, it's only led you to have an extra awareness and appreciation around trauma, sensitivity for victims, you know, just in general. So I'd like to give you an opportunity to speak to, from your perspective, how that'll impact you as a district court judge, having been involved in so many of these extreme scenarios.
So I think my experience having worked, not just with victims who have a trauma history, but when I was a defense attorney, many, if not all of them, also had a trauma history. I would take all of that with me. As I indicated, I think just a few moments ago, it's really important as a judge to consider that in a disposition, to understand what is going on with that particular person, whether it's trauma history, if treatment's available, whatever the underlying issue is. It's important to try and direct them towards an appropriate treatment that will help them with that issue.
So I would hope, given this, your experience, you're very aware in your communities, what resources are available from a diversionary standpoint. Would your inclination as a judge be to avail yourself in judgment in finding potential, or how would you approach diversionary programs in terms of how would you determine who you would want to send to that kind of a resource versus let them get programming while in jail, you know? You know.
So I think in terms of people going to diversion, there are several factors the court has to consider in doing that. Some of which are, you know, what the person's prior record is or lack thereof. Also what they're being charged with. Is there a diversion that would be appropriate to them? And I would like to think that I would take all of my experience, and where a person is eligible for diversion, let them have that opportunity.
I appreciate that. So one of the areas that I wanted to explore with you is the evolving science around emerging adulthood. And you know, just it's an area of concern for me looking at our incarcerated population. The vast majority of those incarcerated in our state, their originating offense was during this emerging adulthood period. You know, district court can be that first foray. And the outcome of that experience feels like, you know, the movie Sliding Doors, where it could go this way or it could go that way. It's like, you know, what pathway is this person, you know, where are they headed? So I would just like to hear, your thoughts around the emerging science and the implications in the courts, but also as a judge, how you would proceed in sort of keeping that consciousness around, you know, who's before you and and sort of,
Well, as you indicated, many of the people who first come into court, and usually the district court, they are young adults. And I think it is important as a judge to consider all of the factors. And one of the factors that must be considered is the person's age. And with a young person, as you mentioned, it may be an appropriate time to get them into some treatment or a program that would help them. And I think it's important to consider that because, as you indicated, it's possible that your first appearance in court as a young adult may send you in one direction or another.
I do think, having spoken to people who've been court involved, judges can really, they can make a difference. They can be inspiring and motivating and underscore that, here's someone who believes in them and what they could be and send them into a positive direction, or the reverse can be true. So it's important to me that, from the bench, ideally we have judges who are doing positive work, especially at the district court, frame the community court. I wanted to comment on one other, or actually maybe two other things in your application. First off, I said this to you when we met, but I very much appreciate, let me find it. There's a question on the application that's asked of everyone that is about whether or not you belong to any organization that discriminates. And so far, you're the first application I've seen that the answer is not no, even though there's been like things alluded to that are kind of self-limiting memberships. You're the first to actually just acknowledge it and just say, why, yes. And you've already talked about your work with the Milton's Junior Women's Club, and so it is for women 18. So I just want to validate and applaud you for just owning that. And I would encourage others to just be frank about, there are clubs for a reason that are for a certain group, and doesn't necessarily imply malicious, malignant reasons. And then we were talking. There's a part of your application, we asked why you want to become a judge. And in your answer, I had shared with you the line that jumped out at me, which is that it's one of your closing line in that section, that every decision a judge makes pulls at a thread that impacts every aspect of a person's life. And it was a powerful statement to me. And when I shared with you that it was a powerful statement, you actually went deeper and further, making an even more powerful analogy for me about knitting and pulling on threads. And so I just want to give you the opportunity to share that with all of us, because I appreciated it.
Sure, absolutely. But what I'm referencing there is something in needlework, and in particularly knitting, but I assume in all needlework, if you pull the yarn tightly, the entire piece will shift in one direction, and it affects the shape and the entire course of that scarf, for example, that you might be working on. And I do feel that decisions that judges make can have the same effect on not just the person in court, but their family and their greater community.
Yeah, I think that is so true, especially district court, but I think all of our courts, there's a greater picture that person, represents one facet of a much broader contextual community impact that can happen. I just very much enjoyed our conversation. I think I'll just validate what I've heard from others said today. My impression too is your demeanor is exactly what one would want to see. Your life experience has just led to, I think, will contribute to being a really great district court judge. And I'm glad to have met you, and I appreciate all the time. I hope it's been a good experience.
It has. Yes, thank you.
Thank you.
Thank you, Councillor. Thank you for all the time you afforded me. It was such a pleasure meeting you. You are unique. I've been here 25 years, and I haven't had someone before me that really has been involved in disabilities. And that concerns me. How many judges really understand disabilities? I served on the Commission on Disabilities for 22 years, so it is, something of importance to me. But I'm impressed that you've gone beyond to learn more about it, because we have disabled people that are being raped and assaulted by paraprofessionals in schools and hospitals. And got a letter from the Child Protection Unit, and she, Joanne.
Cito.
Oh, yeah, and she talked about that you consulted with one of the preeminent experts in crime victims with disabilities. That says a lot. I don't know how much education our judges have on disabilities. And transgender, this is, fairly new coming in. How many really understand? I don't know. Is there any program? Do they educate? Did you get educated on it, or, on this subject?
So I'm assuming that the courts have many educational programs, but I don't know that yet. My office, does a lot of trainings and education on bias, in particular, implicit bias. But also with, you reference, the case, that Joanne Cito wrote about, that individual, I had to learn about his disability so that I could understand him and I could help him get through the court process. And was lucky enough to have available to me an expert in the field of disabilities, in particular with children, who've all spent a lot of time talking to me and educating me.
The thing is, transgender is everybody's learning, I'm sure. But I don't know if you saw the Globe, it was yesterday or the day before, and there was a girls' team, and there was a man that was transgendered, and 3 of the girls were injured. And I don't know whether that's just isolated or what, but the coach, it took that right out the game, right out of the spectrum at all. And I thought that was a noble way to do it. But there's a lot of things that have to be, looked at. So I hope that there is some educational program for the judges to understand, So one of the things that I can't even imagine being involved in all of these. You've had a lot of rape cases with children, horrendous what some of these children have gone through. And, I'm very opinionated, and I follow the Harmony Montgomery case. And I blame the Massachusetts judge. If he hadn't given custody to the father, she was going to be adopted by a couple who adopted Harmony's brother. She had a little brother that asked for her every day, and they were trying to find her to adopt her. So enough said, because I'll get upset about that. But the thing is, you had a 3-year, tell me about that 3-year-old, the case of the 3-year-old.
Sure. I had a case where I helped a family reunite. My client had custody of a family member who gave birth to a child when she was approximately 16 years old. And he then had custody of her baby, which was a little boy. At some point in the process, the mom had moved out and she was having visitation. And at some point, due to a clerical error, custody was returned to the biological mother, who unfortunately suffered from mental illness. And during an episode, she attempted to kill her young child. And I worked with my client, who was an uncle, to reunite the family. There was a care and protection case, and I was able to work with my client and help him get the child placed with him in Georgia. And then ultimately, he was able to adopt this little boy, who I have now heard is in college. So I'm not sure I should call him a little boy anymore.
You've had, I'm just reading these cases. I can't imagine you having those cases and going forward to it. So shows me how qualified you are to be a judge, because I've been here 25 years and people don't have this experience, you know, because you've had a lot of children that have really horrific cases. There was one that was, the mother died, and she was 1 year old. Remember that case?
It was a rape case I had. The victim was 16 years of age when she was raped by a classmate. Her father had died when she was a young child. Her brother had died when she was an adolescent, and then her mother had died. And she appeared at school during the day of the MCAS test, and she was extremely intoxicated and passed out in the woods behind the school when she was raped. And ultimately, she didn't testify at trial because whenever the trial came up, it would cause her to spiral and was very detrimental to her mental health and also her physical health. I was able to proceed without her testimony at trial.
I like your writings, your sample, very good. So you like to write?
Yes.
So why don't you tell us about that case?
So that was actually a rape case as well. It was something that you don't see all that often. It's called a Frank's motion, where the defense attorney was requesting that evidence be suppressed because there was a statement in an affidavit that was intentionally untruthful or misleading. And we had there needs to be a preliminary showing to entitle the defense to an evidentiary hearing in that case. In that particular case, in order to save time and for judicial economy, we did both hearings together, and then the judge ultimately decided that the defense had not met the standard to get the evidentiary hearing.
What is, when you look back, what is the most complex case that you had that comes to mind?
I would say that most of my cases have
all of them
have a complexity. Each case has a different complexity. I, as you mentioned, have had cases, sexual assault cases, for example, with a disabled victim, and the complex issue in that case may be figuring out how to get this individual through the trial. How am I going to be able to let them tell their story in court and have accommodations for them that will allow them to do that?
So, looking back, and you look at all these cases, was there one that you lost that'll always be in your mind that you wonder if it could have been a different judge, it could have gone a different way?
So I don't necessarily rather look at cases in terms of winning or losing, because I think often the most important part, either for a victim or for the defendant, is the opportunity to tell their story. And I think the reason why a lot of cases don't resolve short of trial is because these people need to go to court and tell their story. So I don't really, the disappointments I've had in my cases aren't really result driven.
Do you think there's racial discrimination in our courts?
I think that the courts are doing the best they can to address these issues. I think we can always do better. I think with more education, not just for judges and attorneys, but for all of the court staff, we can do a better job on addressing these issues in the judicial system.
Can I tell you my opinion? I'm not an attorney. I'm a full-time governor's counselor. And I go out to the prisons and I meet with inmates who are petitioning for commutations. And after I talk, and they're black men, they're discriminated against. And I have gone into my car and just cried because it is so horrific what they've gone through. One fella, he was 20 years old. And he was and never had any criminal record or anything. He did well in school. He was just a good person. And he went out with a older friend, 26 years old, and they stopped at this house and they went in. And his friend went into another part of the house, and I'll give the name. William did not know that his friend stabbed someone 12 times, stabbed him to death. He had no knowledge of it. They went out of that house, went home, he had no knowledge of it. William was sentenced life in prison without parole. I know that's the law. They should look at these laws and change them. He wasn't beside him, he wasn't in the room, he didn't even know. So this is what I see. And all I can think of is how many black men in prison don't have an advocate to have a commutation. And that's what I'm concerned about. I really am. And then on the other thing, the parole board, I don't think judges or anyone are looking at that. I am, and we have to increase it. There's only 7 and we need 9 because they're going from the western part of the state to the Cape and they're burned out. And the thing is, they have to give time to the hearings and to give a timely decision. And the thing is, they don't have time for the LIPA hearings or commutation or pardon hearings. And that's what I'm concerned about. And I've talked with the governor about it, and she's partnering with me to get more commutations. But that's the fact. And I know it's wrong. How am I going to change it? But I think that legislation, if we could get legislation through, I think that would help so that we could have some justice for these people. So are you involved at all in any of that process as far as people that have gone to prison that you have, you have probably represented?
I have not personally been involved in any parole hearings for clients that I represented. Unfortunately, the clients that come to mind who went to state prison when I was a defense attorney, they're probably not parole eligible yet, the ones that come to mind, so I haven't been personally involved in those. But I do often think about some of my clients who took a rather lengthy sentence in order to avoid, as you talked about, a life sentence without.
Yeah, 20 years old, he's 54 years old now. And so when I met with William, I said to him, "We'll get you that commutation, and when you get out, I'm bringing you to an Italian restaurant in Watertown." And I did. And I'll never forget it. And he was only out about 3 or 4 months, and I didn't want to cry, but it really touched me. I said to him, "William, what was the most important thing that's happened to you since you've been released?" And you know what he said? "Maryland, I've got my driver's license." How we take it for granted, so I'm just saying that how many will never know in prison, and we're not going to be able to address them all, and that's it. But I think, I don't know, I'm upset with some of these judges, and I think it's not equal, all justice. And I was so upset getting back to Harmony's case and what that judge did when he knew the father was a vicious man. He shot someone in the head. He's been in prison, and he even admitted that he was beating up this child and having her clean the toilet with a personal toothbrush. It was horrible. And she was disabled. She was blind in one eye. And when I look at that and I say, what is a judge thinking when they're doing something like that? And so I called Judge Butt and I says, I want him removed from the recall. And I found out he wasn't. So I'm just saying that it could have stopped there. So I don't know. There seems to me, and it's not up to you, there should be a review of judges. We in the council have an industrial accident board. and we have a review when they're up for reappointment. And it's like a report card, and it's wonderful, because part of it is questions of, has there been any questions of discrimination? Has there been any complaints from attorneys or whatever? So it's good, it's a report card, so you know if they really are, you know, the kind of judge that should be there. So I wish we had that, you know, for all judges. I'll get off my soapbox, but the thing is that I really was impressed with, you know, I don't know how you sleep at night. I mean, these cases, I just unbelievable. But we need someone like you that has done the work, and you know, and I also got a letter from Julie. I'm going to screw this.
Bazuski.
Say it for me.
It's Julie Bazuski.
Okay. So she wrote a letter and talking about, you know, how she's worked with you and the child abuse unit, and all about your, you know, how you treat everyone the same, and you've gone the extra mile. It's a beautiful letter, and also, you know, to know from these people who work with you, just what you do. But I'm even meeting with you to get to know you. It was very important to me, and I felt that too. So I'm going to be very pleased next Wednesday to make a motion for your appointment, and I think I'm sure it'll be very, very favorable, and you had wonderful witnesses. You couldn't have gone the best, really. So I'm very pleased with that, and thank you all for coming, and I'm going to adjourn.
Now, can I leave